Durkheim is nearly here and will be joining us momentarily. We've also started to live stream. And so at this point, we're going to begin the series of confirmation hearings held by the Joint Standing Committee on the Judiciary. We always begin our day with committee member introductions, and we'll do that in a moment. And just to let those who are listening to this meeting or watching it on YouTube, we have 2 confirmation hearings this morning. We have Justice Stokes and then Judge Cashman. And so we will begin, as I said, with committee introductions. And I'm just going to call on committee members, beginning with you, Representative Thorne.
Thank you, Madam Chair. Good morning, everyone. My name is Representative Jim Thorne. I represent Carmel, Herman, and a portion of Etna up in Penobscot County.
Representative Reckett.
Morning. My name is Lois Reckett, and I represent District 31, about to transform into 122, and I represent the ocean end of South Portland.
Representative Sheehan.
Good morning, everyone. My name is Erin Sheehan, and I represent House District 12, which is part of Biddeford.
Representative Newell.
Thank you, Madam Chair. Good morning, everyone. My name is Rena Newell, and I represent the Passamaquoddy tribe.
Representative Poirier.
Thank you, Madam Chair. I'm Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Representative Evangelos.
Thank you, Madam Chair. And, good morning, Justice Stokes.
Good morning, Representative.
I'm Jeffrey Evangelos, House District 91, and I reside in Friendship.
Representative Moriarty.
Thank you, Madam Chair. Good morning, everyone. I'm Steve Moriarty, representing Cumberland and part of Gray, which together make up District 45.
Representative Babbage.
Yes, thank you, Madam Chair. Good morning, everyone. 11th time is the charm as far as getting in on the link. My name is Christopher Babbage. I represent House District 8, which is most of the town of Kennebunk.
Representative and Co-Chair Harnett.
Thank you very much, Madam Chair. Welcome all. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner, where I reside.
Thank you. And I'm Ann Carney. I'm the Senate Co-Chair of the Joint Standing Committee on the Judiciary, and I'll be running this morning's hearings. And so with that, we'll begin. This is a public hearing of the Joint Standing Committee on the Judiciary for the purpose of considering the nomination by the Governor of the Honorable William Stokes of Augusta for the reappointment as a Superior Court Justice. Under the law and joint rules of the legislature, this committee is required to hold this public hearing to recommend confirmation or denial of the nominee by majority vote of the committee members present and voting. As chairs of the committee, we will then send written notice of the committee's recommendations to the President of the Senate. The committee will hear testimony from and have an opportunity to question the governor or her representative, the nominee, and any other persons present who wish to speak for or against the nomination. This meeting is currently being live streamed on the committee's YouTube channel. This means that anyone who is a participant in the meeting via Zoom can be seen and also heard if their microphone is unmuted. People testifying cannot be seen or heard until they are called upon to speak. This meeting will be recorded and available to view on the committee's YouTube channel soon after the meeting has concluded. Now we will move on to the motion to confirm. Pursuant to Title III, Section 157 of the Maine statutes, which requires that there be an affirmative motion to recommend confirmation of the nominee, the chair recognizes Co-Chair Harnett for the purpose of making such a motion.
Thank you, Madam Chair. I move that the Joint Standing Committee on Judiciary recommend confirmation of the Honorable William Stokes of Augusta for reappointment as a Superior Court Justice.
Thank you, Representative Harnett. Is there a second? Seconded by Representative Moriarty. Thank you both. A copy of the statutory requirements for this position has been posted online and available for public review. The chair now recognizes Jerry Reed, the representative of the governor, for the purpose of making a statement concerning this nomination.
Good morning, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Jerry Reed. I'm counsel to Governor Mills, and it's my pleasure to be here this morning to present the Honorable William R. Stokes as the governor's nominee for reappointment as Justice of the Maine Superior Court. Justice Stokes has had a remarkable career that has included public service at both the state and federal level, private practice, and now service on the Superior Court. He's a graduate of the University of Massachusetts at Boston, where he majored in history and minored in chemistry, and holds a law degree from Suffolk University, where he served on the law review. Upon graduation, he accepted a clerkship with Justice James Archibald of the Maine Supreme Judicial Court. He then began what would be a 35-year career with Maine Attorney General's office, interrupted only briefly by stints in private practice and at the U.S. Attorney's office in Portland. In the AG's office, Justice Stokes spent time working in civil litigation and general government practice, but his primary focus would be criminal law, both as a homicide prosecutor and serving for 13 years as chief of the criminal division. There he earned a sterling reputation as one of the state's most knowledgeable criminal lawyers and most well-respected trial lawyers. In 2014, he was confirmed to his first term on the Maine Superior Court. There, Justice Stokes has earned a new reputation as an insightful, smart, patient, and highly productive judge with particular skill in presiding over jury trials. His reappointment to a second term is richly deserved. It's my pleasure to recommend him on behalf of Governor Mills for reappointment to the Maine Superior Court. Thank you very much, and I'd be happy to answer any questions you may have of me.
Thank you very much. The chair would now ask if any member of the committee has questions for Jerry Reed at this time.
Yes. Wait a minute.
Representative Babbage, you can go ahead with your question.
Thank you very much, Madam Chair, and good morning, Mr. Reed. Good to see you again, and thank you for your contribution in this regard.
Good morning.
I wanted to ask a process question, if I may. As you approach this task, you're forwarding a nomination, and my question is generic, not with regard, but I would like to understand the process. I wanted to know if part of your preparation for this was actually recruiting or requesting supportive testimony by the legal community.
We do not recruit supportive testimony from the legal community for judges as a rule. I can't remember any examples of where I've been involved in doing that. I think that generates naturally because the legal community follows these proceedings closely, and inevitably the people that we put up for nomination bring with them their own support because people want to be heard and support these fine candidates. But the governor's office is not directly involved in recruiting support.
Thank you. Thank you, Madam Chair.
Committee members, any other questions? I am not seeing any. Thank you very much. And at this point, we will proceed with a second representative from the governor, and that is John Hobson, and you may proceed.
Thank you very much, Senator Carney, Representative Harnett, members of the Joint Standing Committee on the Judiciary. My name is John Hobson. I'm chair of Governor Mills's Judicial Selection Committee. On behalf of the committee, I'm here to support the reappointment of Justice Stokes to the Superior Court. Mr. Reed has given you the really stellar public service history of Justice Stokes. It's really actually fairly remarkable. And when Justice Stokes, then Private Citizen Stokes, was first nominated to the bench, I was on the committee with Governor LePage, with Josh Tardy as chair. And I can tell you that committee was very enthusiastic about then Private Citizen Stokes' candidacy because he had a sterling reputation among the trial bar as a trial lawyer. Now, there's always a question in terms of when someone comes from the prosecution side of the fence of whether they're going to be able to see both sides. Candidly, the committee was confident based upon back then that that would happen. And I'm here today to tell you that after 7.5 years, not only has that happened, but Justice Stokes is probably listed as one of the best judges by criminal defense attorneys to try a case in front of, because he thoughtfully thinks through the issues. They have he's absolutely fair in his determination, and he understands their argument. I can tell you from personal experience, it's just a great help to have a judge on the bench who understands your argument, can think it through, and you may not end up winning, he may not agree with you, but he's understood your point and has been able to articulate why he didn't rule your way. And Justice Stokes, as you know, candidly, the committee thought 7.5 years ago, has gone on to really have a stellar career for the citizens of the state of Maine. He is one of the trial judges that is the favorite of the trial bar to try cases in front of. I'm sure when he presented himself, and if anyone was here before, you will know and you will see today that his manner is such that he genders confidence and the control of the courtroom in a way that is basically commanding but not stifling. So with all that, on behalf of the committee, the committee supports another 7 years of public service in the long history of public service for Justice Stokes. I would obviously be pleased to take any questions.
Thank you. Committee members, are there any questions for John Hobson? I am not seeing any. Thank you very much, John. The chair now recognizes the Honorable William Stokes for the purpose of making a statement concerning this nomination. You may proceed.
Thank you, Senator Carney and Representative Harnett and distinguished members of the Joint Standing Committee on Judiciary. My name is Bill Stokes, and I want to thank you for this opportunity to speak to you concerning my nomination for reappointment to the Maine Superior Court. I am deeply honored and humbled to be nominated for another term on the Superior Court. I want to express my profound appreciation to Governor Mills for placing her trust in me to serve as a Superior Court Justice. I also want to thank Governor's legal counsel, Jerry Reed, and John Hobson, and the staff of this committee and the Legislative Information Office for guiding me through this renomination process. Some of you I have known quite a few years, Representative Harnett and Representative Reckett in particular, from my time while I was working at the Attorney General's office. I also believe I've had occasion to meet Representative Evangelos as well, and I am pleased to see him again. Representative Moriarty, I apologize. 7.5 years ago, you were sitting on the Judiciary Committee for my initial nomination, and I didn't remember that, to be honest with you, but when you mentioned it, I did recall it, so awful to see you as well. I apologize. But many of you I have not had the pleasure of meeting since I have been away from the State House and the State Office building for almost 7.5 years now, and so it may be appropriate to tell you a little bit about myself. I was born and raised in Cambridge, Massachusetts, and I certainly hope you do not hold that against me too much. I came to Maine in the summer of 1976, fresh out of law school, to clerk for Supreme Judicial Court Associate Justice James P. Archibald of Holton. After making the long drive up I-95, and trust me, it was a very long drive, I finally arrived in Holton to begin my clerkship. One of the first persons I met that day, and I remember the day very vividly, Friday, July 30th, 1976, was Diane Doyen of Mapleton, who was serving as Justice Archibald's summer law intern and who was about to return to Boston College Law School to complete her third year of studies there. My plan at the time was to finish my clerkship and then return to the Boston area. But something happened to me that I did not anticipate. I fell in love with Justice Archibald and his wonderful wife, Lita, both of whom mentored me and looked after this city boy who was far from home. And I fell in love with Aroostook County and the state of Maine and its people. It would take another couple of years for me to fall in love with Diane, but that eventually did happen when, following my clerkship, I took a position in Augusta and met up with Diane again. She had finished law school and had returned to Maine as an assistant attorney general. Diane would serve in the attorney general's office for 34 years, doing a variety of jobs, but primarily handling child protective and child support enforcement cases. In August of this year, Diane and I will celebrate 40 years of marriage, the result of a wedding ceremony presided over by none other than Justice Archibald himself. We have lived in Augusta in the same home for 39 years. We raised our two children, Alicia and Liam, here in Augusta. I ended up serving over 35 years with the Attorney General's office before I joined the judicial branch of government as a Superior Court Justice in 2014. And Representative Moriarty, thank you for that kind memory. When I appeared before the Judiciary Committee in 2014, I said that I felt blessed by good fortune, far exceeding anything I may have deserved. I still feel that way. Serving on the Superior Court of this state has been an honor that mere words cannot adequately describe. And I'm not being facetious when I tell you that I often wake up in the morning and pinch myself to make sure I'm not dreaming that I've been granted the privilege of serving as a justice of the Superior Court. The men and women with whom I serve in Maine's judiciary, district, superior, and Supreme Courts are not just outstanding judges and justices. They are caring, compassionate, and dedicated public servants who love this state as we all do, and who place the pursuit of fairness and justice at the top of their priorities every day of their working lives. But it does not end there. The clerks, the marshals, the support staff with whom I work are extraordinary in their dedication to the state of Maine and have been simply heroic in working under conditions rarely, if ever, seen during our lifetimes. Many of the lawyers I am privileged to work with are as skilled and professional as any you will find anywhere. And our juries, people from all walks of life and with a diversity of backgrounds, are nothing short of amazing. These men and women have come into our courtrooms all over the state during a pandemic, no less, and have served as jurors without complaint so that the right to a jury trial can be preserved. Remarkably, they end up thanking us for the privilege of serving. My colleague at the Capitol Judicial Center here in Augusta, Justice Murphy, and I have spoken of it on more than one occasion, and both of us get emotional in our admiration, respect, and downright awe for the citizens of this state who serve as jurors because they want to be part of our constitutional system of justice. They do it because they know how important jury service is to our democracy. And so Senator Carney and Representative Harnett and members of the Judiciary Committee, particularly Representative Moriarty, here I am again, 7.5 years later, appearing before you to ask for your approval that I may continue to serve on the Superior Court of the state. I ask it because I love it. I love the people. And I love being part of our common commitment to civil and criminal justice for all our fellow citizens. This is not to say that the last 2 years have been easy. You know it as well as I do. The job of government in a democracy is to serve and to involve its people in self-governance. And that means bringing people together to appear before legislative committees and executive agencies and the courts. Yet for the past 2 years, we've had to tell our citizens to stay away from us. While I have been discouraged over these last 22 months of the COVID-19 pandemic, particularly with the backlog of cases we are dealing with, I remain hopeful for the future, and I believe I still have something to contribute to our system of justice. I hope you agree. And it is with a deep sense of humility that I ask for your support of my nomination to the Superior Court of this state. Thank you, and I would be pleased to answer your questions at this time. And I don't know whether I've lost the link.
No, you're all set.
I'm sorry.
Justice, I think you might need to mute because we're getting some feedback here.
Wow, now how do I do that? I'm trying to find my mute button. And I do not see it.
Maybe.
Hold on, I got it.
I think we're okay now. Okay, thank you. And Justice Stokes, thank you so much for your statement and for your service to the state of Maine. The chair will now ask if any of the committee members have questions of the nominee, and I see that we do have a question from Representative Babbage. You may proceed. Well, actually, Representative Babbage, before you proceed with your question, and I'll ask other committee members as well, I'd like to give Senator Keim a moment to introduce herself, and then we'll proceed with your question.
Good morning, everyone. Sorry to be late. My name is Lisa Keim, and I represent Senate District 18, which is Northern Oxford County.
Thank you. And you may proceed, Representative Babbage.
Thank you, Madam Chair. I appreciate it. Great to see you this morning and meet you, Justice Stokes. I appreciate your long service, and I appreciate the words you shared with us. I have a couple of questions that are, really from 30,000 feet, but one of them has to do with, what would I call it? Integrity, perhaps, or how we view ourselves. As a legislator, I would hope that even my opponent in an election would trust me to count the ballots and be fair in that result. I'm likely to be a little overly fair and point out ballots that are clearly mine, but making sure that he agreed with that if there was any kind of contentiousness. And I'm sure that those of us who are put in a position of trust, as you are, also feel that public perception and your integrity is beyond question. With that in mind, what have you ever recused yourself from a case, and under what circumstances would you find that advisable?
The famous words we've now learned to say is go unmute yourself or mute yourself, I guess. Representative Babbage, nice to meet you. And I have, on a couple of occasions, recused myself. Recently, I did because of I happened to be sitting on the bench going over the arraignment list, and it was quite a long list, 80 people. And as I went through the list, I recognized a name, and it was a relative through marriage who was appearing. And so I did recuse myself. I made sure that it was the person who I thought it was, and I recused myself. So I have recused myself. There are cases when I've been asked to recuse, I think just one, and I declined because I didn't feel that there was any basis for me to recuse myself. I explained my reasons. That issue went to the law court, and they fully discussed, my decision not to recuse myself and agreed with it. Because there is an obligation to recuse yourself when you should, but also not to recuse yourself when you shouldn't, because you have an obligation to hear the case. As much as you might want to get out of it, you have an obligation to hear the case and to preside at the case if you can do it. And so I'm guided, obviously, Representative, by the Code of Judicial Conduct, and I look at that very closely. And if there's any question where I feel that I cannot be fair, or even if I feel I can be fair, but that it might be perceived that I cannot be fair, or it might be perceived that the public may have less confidence in me presiding, then I would recuse myself. So it's an ongoing thing. We deal with it all the time on cases as to whether or not, I served as mayor of Augusta for 3 years, also served on the city council for 7 and the school board for another 7. So, I know a lot of people in the city of Augusta. And early on in my judiciary term in the judicial branch, I would almost err on the side of disclosure, tell them, where I came from, that I was with the city of Augusta. And if they wanted me to recuse, for example, I would do so. That lasted about 2 years. Basically, the rule that the judicial department gave me was, for 2 years, I should not handle any cases from the Attorney General's office. And for a couple of years, I also didn't handle any cases from the Augusta Police Department, and would disclose to the parties why I was recusing myself. And even in cases where I didn't feel I had to recuse myself, I would disclose, so that if they felt that they would prefer not to have me sitting on the case, and I said I would honor that. So.
Okay,
It's an ongoing thing, Representative, that you're always thinking of to make sure that not just that you subjectively feel you can do it, but you want to make sure that anyone looking at the case from the outside doesn't feel that, the scales are being tilted one way or the other. And even if that's not true, perception is, as you pointed out, perception is a huge part of how we operate and how all the branches of government operate.
Right. And regarding that perception, I mean, especially I think in recent history, institutions in this country have been under attack, and I think confidence in them has been eroded. I wondered, as a judge, do you feel that the institution that you represent needs to be protected?
Well, I'm not sure protected. I mean, I think we can sort of take care of ourselves. I watch the news like you do, Representative. I have concerns about, I want to make sure that people have trust in all branches of government, whatever it is. And I am concerned when I run into people who don't have faith and confidence in our system, either of a system of justice, our elected system, our executive branch. I think we all are here to serve our fellow citizens. And part of that service is to make sure that they have confidence in what we're doing, and that they, and so I try to behave in a way that instills confidence, that they can trust, that I can be fair, and that they're welcomed in the courtroom, and that this is their courtroom. It's not my courtroom. It's their courtroom. And I want to make sure that they understand that this is a place where they can trust their government. But all of us, recognize that there are, members of our citizenry who don't have a high level of confidence, in any of the branches of government. And I think, the way we reach them is to act in a way that instills confidence in them. And I try to do the best I can with that. I hope I'm making some progress. But I think it's the way we live our lives and the way we conduct ourselves. That is the best way to instill confidence in our system of government. It's a system of government that's run by human beings, so it's going to have its failures. And and I think all of us in all branches of government, try to conduct ourselves in a manner that instills confidence by our fellow citizens. And when they leave that courtroom, they feel that, well, it's not an experience I want to go through. Usually coming to court is not a pleasant experience, but I at least want them to make them feel they were treated fairly, and this is a place that's not to be feared. It's part of our it's part of our way we govern ourselves. Governing ourselves is what we do in a democracy, and I want them to feel that this branch of government that I'm serving in now, respects them, and that when they leave that courtroom, they feel that they've been treated with respect and with fairness.
Yeah, Madam Chair, if I can wrap up.
Representative Babbage, you've had a question and
Okay.
a follow-up, and I'd like to turn to some other committee members.
I'd be glad to do this later. Absolutely.
Representative Evangelos, go ahead with your questions.
Thank you, Madam Chair. Justice Stokes, that was a very moving opening remarks. And I wanted to tell you that Mr. Hobson's remarks make me very encouraged, because those are the kind of signals criminal justice reformers are looking for. I have a series of questions, Madam Chair, regarding the topic of post-conviction review in our state. So I just wanted to be able to proceed and complete the thought process. Would that be okay?
How many questions do you have?
I'm not sure. It depends upon the answers.
Okay, well, I would encourage you to try to do a question and a follow-up, and then just let me know how far along you are, because other committee members do have questions.
We can always circle back a second time, right? Okay, that'd be fine. First of all, Justice Stokes, I wanted to make sure jurisdictionally I'm in the right place. But when a motion for post-conviction relief occurs from an incarcerated individual who is maintaining their innocence, that does typically arrive at Superior Court. Am I correct in that?
Petitions for post-conviction review under the statute are filed in the Superior Court. That's correct.
Okay. And in the interest of full disclosure, I did quite a bit of research on this, and the gentleman who recommended you highly for the job, Walter McKee, and I have collaborated for almost 5 years now in reforming our post-conviction review system around the onerous time limitations on hearing newly discovered evidence and the due diligence standard. And we have a bill sitting in the Appropriations Committee that will fix that. I was discussing this with Mr. McKee over the weekend, and I asked him to forward you some information about my line of inquiry so you'd be prepared. Did you receive that?
I received that last night, Representative.
Okay, thank you. So one central question I have is, when the United States Supreme Court in a majority opinion makes a ruling, which they have similarly in Giglio, Miranda, and Brady, isn't it incumbent upon a state to abide by the superseded powers delegated to federal court decisions?
Well, if it's made applicable to the states, and in those cases that you've mentioned, Giglio, Brady, and Miranda, those are all decided obviously under federal constitutional provisions that are applicable to the state. So where those Supreme Court decisions are made applicable to the state, then obviously state court judges are required to follow them.
So the reason I ask is in 2013, the United States Supreme Court voted 5-4 in a case called McQuiggan versus Perkins, in which Justice Ginsburg held that courts must circumvent any time limitations or statute of limitations on the introduction of evidence when the claim by the defendant that has claimed that he is innocent has always been innocent. And Ginsburg said that this serves as a gateway through which the petitioner may pass in state courts. Time after time, the Maine Attorney General's office shows up at these hearings and says, sorry, you missed your 1 year time limit, or alternatively, the due diligence standard, your first lawyer should have figured this one out. We don't do that in the cold case homicide. 30 years later, we find evidence and we don't say to the detective, you can't, we're not going to hear your evidence. So I want to know why these decisions continue to go against these defendants when the Supreme Court says that they do have a gateway.
Obviously, Representative Evangelist, I can't speak about any particular cases that that have been pending in the Superior Court. I would point out that the McQuiggan case that you referenced was decided under the federal habeas corpus statute. So unlike Giglio, Brady, and Miranda, which were decided based upon constitutional principles, the Fifth Amendment, the Sixth Amendment, the 14th Amendment due process clause, which is made applicable to the states, in that case, they were talking about access to federal habeas corpus. And so that decision would not necessarily be binding on the state because it's not applicable to the state. It's really an interpretation of the federal habeas corpus statute. And I think that's the explanation for that, I would say, Representative Evangelos.
Well, Maine law, according to Justice Mead in a 2015 decision, is silent on the claim of actual innocence as grounds for post-conviction relief. And I believe in this McQuiggan case, it was applying to a state court's impediment to introducing this evidence. So don't you think this is an extremely important precedent that our Superior Court justices should be taking into consideration? I mean, let me put it this way. You or I have a son in prison. They're innocent. And, well, it wouldn't happen with you because he's got a pretty good lawyer, but a person has a son in prison and they're innocent. They've been there for 20 years. You're isolated. You have limited phone contact. You don't necessarily even know that the newly discovered evidence has surfaced, and you miss your 1 year time limit by 5 days. It just seems to me such a grave injustice that a person has to be denied the right to hear these witnesses that could free them on such a petty procedural ground. One other thing, the bill that Walter helped me with.
Representative Evangelos, could you just pause there and let the nominee respond to your comment?
I want to complete this thought, and then we'll move on, okay? I'm right in the middle of it, Senator Carney. The bill we produced was based on the Massachusetts Criminal Code, and let me read what it says. The fundamental principle of this rule is that where it appears that justice may not have been done, the valuable finality of judicial proceedings must yield to our system's reluctance to countenance significant individual injustices. And that's what Justice Ginsburg is saying here, that there has to be a gateway for somebody that's innocent in prison to get a hearing when witnesses surface. And without getting into specific cases that are pending in our courts, don't you think this is something our justices need to take a more serious look at?
Well, Representative Evangelos, I guess I preface it by saying, as justices and judges, our responsibility is to apply the law that's given to us by the legislature and obviously by our Supreme Judicial Court and the Supreme Court if it's applicable. So that's our guiding principles. What does the law tell us to do? How do we apply the law that's given to us by the legislature? I don't think it's appropriate for me to comment on terms of how the legislature should do, what the legislature should do in terms of amending the post-conviction review statute. I would point out the McQuiggan dealt with, and it's and the federal habeas corpus statute is a fairly complex area of the law. Congress has imposed limitations on when that ancient writ can be used by the federal courts in the case of a state prisoner. And I think what Justice Ginsburg was saying is that the actual innocence claim can be a gateway to avoid a procedural default, such as you're mentioning, the passage of a statute of limitations or some other procedural defect that may have existed with the petition. And that's what I thought she was saying, is that it allows you to proceed with the petition even though you may have been procedurally defaulted. So I think the answer to your question in terms of why isn't that applicable to the states is I think it really is based upon, the federal interpretation that the Supreme Court has put upon Congress's limitation on the use of the ancient writ of federal habeas corpus when it comes to state prisoners. And they also obviously put limitations on, the use of federal habeas when there's a federal prisoner involved as well. So I think that was their interpretation of the statute, which allows, and it's a balancing act, as you know, Representative Evangelos. There is a value to finality. I mean, for centuries, courts have talked about the need to the importance of finality in judgment, so that it's at some point there is an end to it. But there's also a balance, and that you're talking about, which is when do those the need for finality have to give way to legitimate petitions that need to have a full hearing. And so I think that's the balance that has to be struck. And that's a balance, I think, that the legislature has to make in the first instance, as it crafts the state post-conviction review statute, and which it has done, with that, and also the DNA post-conviction statute. But it's always a balance, in terms of, the need for finality, because there are, people who, are saying, their victims or their families say they want finality. Why is this going on so long? And your point, which is, that at some point, finality is not an end in itself. It's supposed to serve the interests of justice. And that's the point you're making. It's always a balancing act. And you decide those cases, they're fact-specific cases, as Representative, that depend upon the specific evidence and facts that are presented to the judge. And that's how you got to make a decision. So I think that would be my response to you on that, Representative.
Thank you very much. And thank you, Madam Chair, for letting me complete. And if I have anything else, I'll circle back.
Thank you.
Representative Reckitt, go ahead with your question.
Judge Stokes, I have a situation that has troubled me for years, and I only discovered midstream that you had been involved in this particular situation. It's not from your days as a judge, but from your days as a homicide prosecutor. And I bring it up because I hope that your response to my concerns, may not be that tapping all the time, but that your response to my concerns may reflect that your attitude about some issue.
Representative Reckitt, can you just pause your question until we resolve the Justice Stokes? I can actually mute you and unmute you from this side, so I'm going to do that. And I will unmute you again after Representative Reckitt's question is completed. Go ahead, Representative.
Thank you. I'll start again because I suspect you didn't hear a single thing of what I was asking. But basically, my concerns come out of my work, as many of you know, in the domestic violence movement for a long time. And as background to my question, I have to give you the context, which was in the 90s, I think it was, and God knows I don't get dates right, and I don't get a number of minutes and stuff like that. But in the 90s, there was a national movement that began, I think, in Framingham, Massachusetts, to review the cases of all of the women who were incarcerated around the country for murder, and to look at the circumstances of those cases to see whether they gave us any guidance towards what ought to be happening now, and whether or not these women, under the current attitudes about domestic violence, should be in prison still, or should have been there in the first place. And in Maine, we looked at all of the women who had been convicted of murder, and there were few in these circumstances. But one case stood out, and I myself was involved in analyzing and figuring out what we might or might not wish to do about it. So, a woman who was incarcerated at Wyndham, she was a woman of, I guess the term is mixed race. Her father was a white man, and her mother was a Penobscot woman. And she had, at some point while she was caring for her father in his older age, killed him. And when we looked through the case and talked about it internally, we realized that this man who had been killed had been a horribly abusive guy of the mother, of her, of her siblings, et cetera, et cetera. And when I also read the court case, because I read the transcript, I realized that this case was done in, I think, something like 18 minutes, some ridiculously short amount of time. And you were the prosecutor. And I was surprised at that because it didn't fit with my understanding of who you were as a person or what your attitudes were. And I still don't understand the disconnect. So I spent about 4 years on this case and eventually convinced Governor Baldacci to commute her sentence. And I attended the commutation hearing, listened to the testimony from, frankly, a lot of the people who had worked with her in the, I can't remember if it was 12 or 16 or 18 years she had already served in the prison. But in fact, she was granted commutation by the governor and went home to her grandkids and I assume is still living in Penobscot County. So my question to you is, because I know you and I have talked about domestic violence issues over the years before you were a judge. And my question to you is, do you think that in your current understanding, you would have handled yourself differently in this case? Perhaps brought forth the things that I just read from the prosecutor in Kennebec County, talking about your capacity to have a young girl understand at the end of a trial that somebody believed that she had been sexually abused. She happened to win the case, I think, but the other side, even the defendant, felt he had been listened to and heard and that things went well. That's the Bill Stokes that I know and that I hope is continues to be that way. But I want to know whether or not, were you to drop yourself back 30 years or 20 years or however many years it is, whether you believe you have learned some body of truth internally or externally that has helped you, that would have helped you be more like you are today 20 years ago. It's an easy question for you, right?
Okay, I think I do remember the case. If you gave me the name, I would remember it even more. I believe it was out of Hancock County.
Could be.
And it was a woman who was taking care of her father. He was not a very nice man. And I believe there were some details where he had, I think, turned over the house to another sibling. And that created a lot of anger on the part of the defendant. My memory is that she had done target practicing with the gun the day before and then shot him. She was originally charged with murder. We agreed to reduce the charge to manslaughter, I believe. You know, you mentioned the shortness of the case. My memory of that is that I don't believe that was the Rule 11, because I almost know the date, Representative Record, because my son was born in 1997, June of 1997, and I was actually on paternity leave when the plea was done, and we agreed to accept a case was getting ready to go to trial. And I believe we agreed to a reduced charge of manslaughter, and she pled guilty to manslaughter. So the time period you're talking about, I think, must have been the Rule 11, but I have no memory of actually doing that Rule 11 proceeding. I did do the arraignment. I remember traveling to Bar Harbor. That's when the Bar Harbor District Court was there in the old city building, and I remember doing the arraignment at that time. And then I recall that it was I think it was an agreed upon sentence. I do have a memory of Governor Baldacci commuting that sentence, and I believe we supported it. We did not oppose a commutation of the sentence for her because of the fact that, you know, he was a very abusive man. And it was longstanding, it was chronic. She had taken care of him for many, many years during his illness. And so there were a lot of mitigating circumstances that weighed into the decision to accept a a lower plea. So she was never convicted of murder. I believe she pled guilty to manslaughter. Or if it was murder, it was adequate provocation manslaughter. Adequate provocation manslaughter, which is murder, which is reduced to manslaughter because of adequate provocation. That's my memory of that case. And as I said, I don't have a memory of actually going up and doing the Rule 11, because my memory is that happened right when my son was born, and I was out of the office for a period of time. And so a colleague did the Rule 11 to manslaughter. And I supported that. I thought that was an appropriate disposition, given the fact that there was evidence showing that she obviously, killed him, that there had been some planning or pre-thought to it. And we thought the appropriate resolution was a lesser charge of manslaughter rather than murder. Murder, as you know, carried with it a 25-year minimum. And I believe her sentence was, in order to get her out from the minimum, we agreed to a reduced charge of manslaughter. That's my memory of the case. And as I said, I don't have a memory. It was assigned to me, but I don't have a memory of actually doing the Rule 11. That would have been, I think, in Ellsworth, if it's the same case that I'm thinking about. And you're muted,
Representative, we're not able to hear you.
I no longer have the paperwork that I, since I'm not at my previous job, so I can't tell you precisely that. And my question really is more to, do you think your understanding of both domestic violence issues and perhaps I frankly think in this case there was a huge intersection with the attitudes of her father about Native people, including her mother, that made this case volatile on a global level. So my question is do you think that in your time prior to and as a judge have evolved to greater understanding about both the issues of domestic violence and the issues about the treatment of Native people in the judicial system in this state?
I don't have any memory, Representative Record, of the Native American piece to that. That even came up during the investigation of the case. I don't have any memory of that. But in answer to your other question, the answer is yes. I mean, I can tell you my sort of epiphany happened around that time period. I don't think it's any secret in the case that really changed my whole understanding of domestic violence, because I frankly did not understand the dynamics of it at all early on, was Ardolino. And you may be familiar with that case. I did not have a full appreciation of domestic violence. That was the case in which a man killed his 9-year-old son. And one of the first questions, and I was a relatively young prosecutor at the time, and I remember thinking to myself, as I met with the mother, and I thinking to myself, why didn't she just leave? And then I realized after speaking to her that it's not that easy to leave. It wasn't that easy to leave for her. She was under a situation where she was being controlled. There were many things that were controlling her and her decisions, including money, the finances, the fact that she had a total of 4 children, and it wasn't that easy to just pack up and leave. And so my evolution really started with that case, where I really didn't fully appreciate the dynamics of what went on in a relationship that's characterized by domestic violence. And of course, it's grown ever since. Because you see it all the time. But I'll be honest with you, that case was really an eye-opener for me, because not only was there domestic violence against the wife and the mother, but then he took that out. Once she did leave, he took that out on the child. And that was sort of the epiphany for me, where I became much less judgmental. And I think there is a tendency to be judgmental about domestic violence. And I did not fully appreciate the choices she had to make to leave, and how complicated and how difficult those decisions were. I mean, it's not just packing your bags and getting on the bus and leaving. It's much more complicated and much more dangerous than I understood at the time. And so that was 20 some odd years ago. Well, now he says she's going on 25 years ago, and that is sort of, was the sort of the demarcation point where I began to have a better understanding of the dynamic that was going on and the choices that had to be made. And I became less judgmental, I think, than I may have been before that. So I think it did evolve. As I said, on the piece that you mentioned about that case, I remember that case. I just don't remember the name, but I do remember that case, and I remember that it did cry out for a lesser charge than manslaughter. But I don't frankly remember the piece that you mentioned about her being or having a connection to the Native American tribe, whether it was Passamaquoddy or Penobscot. I assume it was Passamaquoddy.
No, it was Penobscot, actually, but
Penobscot, okay.
Yeah.
Because I believe it happened up in Hancock County.
Yeah.
Because I have a memory of traveling to Bar Harbor District Court to do the arraignment or first appearance.
Yeah.
So I think the
I think
Rule
it was
11.
Bar Harbor. So anyway, I appreciate your response, Judge Stokes, and your acknowledgement of your journey.
Thank you.
Representative Harnett.
Thank you. Thank you very much, Madam Chair. Thank you, Justice Stokes. Thank you for your long record of public service and for signing up for another round of 7 years. It's admirable. I want to read part of your questionnaire for reappointment. It was one of your answers, and it really struck me when I read it. And it was in response to one of the challenges that you face and that the judiciary faces. And you said the most significant challenge is and always has been the lack of administrative support. I draft and type virtually all of my decisions and orders, and that is very time consuming. I do have a law clerk, for which I'm very grateful, but the law clerks tend to be recent law school graduates. And my question revolves around judicial resources. And I noted in your statement to the committee, you talked about what we've all been talking about, the incredible backlog of cases, both civil and criminal, that has resulted from the pandemic and the inability to process things as quickly as possible. And nothing against people that type and provide administrative support, but do you think it is the best use of our judges' time to be generating all of their own decisions, typing, getting the paper out? Because to me, it is not. And I'm just wondering what you think about the resources that are given to the judiciary, particularly in light of the obstacles that you're going to face with the backlog moving forward.
Well, I was, as you know, in my prior job, I had secretarial assistants, and then it was an eye opener when they came on to the judicial branch and realized that I really didn't have any secretarial support. I tried the Dragon Dictate. That didn't work too well for me. I spent most of my time editing, and I eventually, just to get decisions out, I write all of them. Obviously, my name goes on them, so I want to make sure I write all of them. But the typing, we all remember when I was going to school, and I'm sure probably when you were going to school, Representative Harnett, that was not perceived as a need. To be able to be keyboarding was not considered something that you would ever need to do. I now regret that. I wish I had done the keyboarding because it would be a lot easier for me to do write my decisions, because, as I said, it's a very time consuming, tedious process for me to write everything, which is one thing. But I used to dictate briefs, you name it, at the Attorney General's office and give it to a very, highly skilled secretary. And would come out perfect. The next time I saw it, it was perfect. It's a very time-consuming process for me to type all my decisions, but that's the resource issue that we have, and it's not unique to me. I mean, I'm not complaining because it's me. We're all doing it. Some people use drag and dictate. I tried that. It's not really supported by the judicial branch. I mean, it's available, but it's not supported in terms of technical support. And so I tried that, but as I said, I ended up doing, editing. I'd be dictating along, and the next thing I know, we were talking about the Appalachian Mountains because it's all phonetic. And so I would find myself, editing everything. And so it just became so time consuming that I finally said, let me just write the darn thing and, get it out because people are waiting, for decisions, and I want to get those out. So it is, I do have a law clerk. She's great. And I share her with another justice. But the bulk of the writing I do myself, and the bulk of the typing I do myself. I sometimes will ask her to, draft a decision, then I'll edit it. But a lot of the decisions I'm doing, I'm typing myself, and it's a process. It's not a pretty sight with me typing. I sometimes joke with juries because I type my own, jury instructions. No matter how many times you proofread it, on the 10th time you'll find a mistake. And sure enough, with me doing the typing, that's going to happen. And so that's the reality of it, Representative Harnett.
Thank you, Justice Stokes. And a quick follow-up, Senator Carney, if I might.
Yes.
And this might be perceived as a softball, but I hope you can answer it. Do you think that the judiciary would be better served and more efficient with additional administrative support for just throughout the system, justices and judges?
I would certainly benefit from it. I can tell you that. I think whatever administrative support we can avail ourselves of is going to be appreciated because, as I said, it is a time-consuming process. You want to give thought to your decisions. On significant decisions, you're not just going to write granted or denied. You want to explain. I think people have the litigants have a right to at least know, what your thinking was and why you reached the decision you reached. And, it's not enough for me to just say denied, granted. I want to be able to articulate what my thinking was, and so that they can understand. So it's a basis for further review if there is further review. And so that is a time-consuming process. So any administrative support that is provided to us, I would certainly gratefully accept and appreciate.
Thank you. Thank you.
Representative Babbage, go ahead with your question.
Thank you, Madam Chair. Thank you. I've appreciated the conversation, Justice Stokes. And, where I was before with you, I was asking about the desire to protect a working institution. But where I was getting at is the working friction there is from protection of the processes and decisions of the institution versus those that would allege wrongdoing or would find issues with it and all of that. And then being able to sit in judgment of those decisions in a fair and impartial way. You mentioned in relation to Representative Evangelos's questions, what I think is really the heart of the question, and that is the finality of judgment and the value of that. And I think that's where I'm going with this line of questioning, because I think I would hope, but I'm not sure that all prosecutors would agree that better that a guilty man go free than an innocent man be punished. But we have roles to play, and we rely on the system to work adversarial system to work in order to get to that judgment. So, I don't know if you have a comment on that, but that there is that friction, and I wondered if you felt comfortable in your ability to balance, as you said.
It's not a one-time event, Representative Babbage. It's sort of a lifetime. I mean, I dealt with that in my former line of work as a prosecutor. You obviously want to make sure that what you're doing is correct, is factually correct. As a prosecutor, I did not want to be involved in a case, where there wasn't sufficient evidence to believe that the person had committed the crime. I mean, that's to me, that would be my nightmare, is that I was involved in a travesty of justice. So I struggled with that, throughout my career. I mean, you were always thinking about it. I mean, at least I was always thinking about it. And I continue to think about it. I think about it now differently than I thought about it as a prosecutor. But because I'm performing I'm in a different position. But I think I've always thought about it. What am I doing? Am I doing the right thing? I think we're always thinking about that. Am I doing the right thing? Am I making the right decision? You can agonize over it a lot, and I think many of us do. Particularly on the criminal side, when if the fate of someone is resting in your hands, you think about it a lot. But even in civil cases, you want to make sure that the litigants are treated fairly. So I think it's sort of a lifetime of I don't think you sort of do it and then stop thinking about it. I think for me, it's been a lifetime of trying to be thoughtful about what it is you're doing, and being satisfied that the course you've set is the appropriate course, understanding that there are countervailing arguments that people may disagree with you, or people may see it differently. But I think it's a process that if you're going to be in public service for as long as I've been in public service, it's not something that you decide once and for all and then stop thinking about it. You can't stop thinking about it. It's a way of life.
I appreciate that. And my line of questioning here is truly generic. It's our job to explore your thinking, and I appreciate your comments. I will tell you, though, the first time I probably read your name was when you were chief of the criminal division, and back when I was a brand new legislator, and that is a while ago. The representative from Aroostook had introduced some legislation regarding the Dennis DeShane case. I don't recall exactly what the proposal was right now, but I was very moved by the representative because he was extremely emotional. It's very seldom you see somebody weeping on the floor of the House. And I couldn't vote for what he was proposing. I don't know if it was because I felt I didn't know enough or if it was a separation of powers issue. But I do know that in the 1990s, an attorney general did hire investigators beyond the attorney general's office to investigate whether or not there had been improprieties regarding withholding evidence of an alternative suspect or destroying a rape kit or something along those lines. Just because you are before me and I have this evolution of experience. Can you tell me what the result of that investigation was and what your thoughts were about it?
Well, I think what you're referring to, Representative, I think it was Attorney General Steve Rowe.
Yes.
I think, and that would have been in the early 2000s, 2001. And he asked, there were three individuals. I think it was Charlie Abbott from Lewiston, Attorney Charles Abbott from Lewiston, Auburn area. There was a former federal magistrate, Eugene Bollier, and I think it might have been another attorney. I think it, wasn't that awful? Can't think of his name, but there was a third attorney, I think, from the Bangor area. Can't think of his name. It'll come to me, but not within the next few seconds. And they did do, and they did issue a report, and they found that there was no impropriety in connection with that. They recommended some changes moving forward in terms of post-conviction discovery and some changes moving forward. But I think that's the panel that you're talking about. They did issue a written report back in, I'm thinking 2004, 2005, maybe in that time frame. That's my memory.
It didn't raise any flags that would make you concerned.
No.
Okay. My last one is a softball, Justice Stokes, but it would help me to understand. You have been, some of your decisions have involved a fine to the Victims' Compensation Fund. What's the criteria as to when to use that as part of a sentence?
Well, it's automatic, Representative.
It is.
Yeah, it is. And it's set by the legislature, and the courts cannot waive it. And I may have had something to do back in the day when I was head of the criminal division in making sure that the judiciary could not waive it. I'll plead guilty to that. For misdemeanors now, it's $25 on a conviction. For any convictions, $25. Used to be, it's gone up over time. It started out as 10, then went to 20. Now it's at 25 for a misdemeanor. For a felony, it's $45 per conviction. That's gone up. Used to be 35 and 25, and it's gone up over time. And what it's used for is it goes into the Victims' Compensation Fund, so that fund is replenished to pay for expenses that the victims may be entitled to. Funeral expenses, counseling expenses, medical expenses that aren't otherwise covered. And the legislature, it was quite some time ago, I'd say 20 years ago, put in a provision that it cannot be waived, because what was happening routinely is the judges were waiving it, and particularly in cases where the defendant would be incarcerated for long periods of time. The thinking was, well, they're never going to pay the fine, but there is a provision in Maine law which allows the Department of Corrections to take up to 25% of a person's income in the prison system and apply that to restitution, fines, victims' compensation. So our thinking was, we need to keep that fund replenished so that victims down the road, that there's money available to reimburse victims of crime. And that's how the fund gets replenished.
The numbers you quoted were
Representative Babbage, I'm sorry to interrupt you, but you've had several questions and follow-ups, and Representative Evangelos has his hand up as well. So if you could ask one final question of the nominee regarding his qualifications, and then we'll move on to Representative Evangelos.
Thank you, Madam Chair. My questions are done. I would just like a clarification on that answer, because $25, $45 sounds like a fee, but you can apply as part of a sentence a $2,000 restitution to the Victims' Compensation.
Yeah, most absolutely.
Okay.
Yeah, absolutely. And a fine. The Victims' Compensation is not considered a fine. It's sort of a fee that's automatically imposed. And then a fine, some fines I can suspend. The legislature has given us authority to suspend certain fines, in a financial hardship. I can't waive the Victims' Compensation fee.
Does the fine go to the Victims' Compensation Fund, or can it?
No, the general, goes to the general fund.
Oh, okay. Thank you very much.
General fund. The fee goes to the Victims' Compensation, and restitution goes to the victim, obviously.
Thank you very much.
And victims and restitution's at the top of the priority list. It's restitution first, fines after that. Actually, I think counsel fees after that, and then fines to the state after that. That's the sort of priority that we're told to use.
Thank you very much. Congratulations on your renomination, and thank you, Madam Chair.
Thank you, Representative Babbage. Nice to meet you.
Representative Evangelos, go ahead with your question.
Thank you, Madam Chair. This will only take 30 seconds. I do want to caution the committee that the criminal defendant that was mentioned in the last conversation has a pending motion before the Superior Court, so we need to be very careful around that. Justice Stokes, and you know this, but the Judiciary Committee, I always called it the Committee of Tragedy and Tears. And, just last week, we heard from people that have been, damaged and victimized. And I'm very sensitive to your arguments regarding the victims. But Rachel Talbot Ross, Representative Talbot Ross, made a very cogent point when we heard the post-conviction bill. You don't have finality when you have the wrong person in prison. And it's not really a question, Madam Chair, but that's my closing comment. And I hope you will give that serious thought going forward in your deliberations. And thank you for that, Madam Chair.
Did you want to respond, Justice Stokes?
No, Senator. I understand. I understand Representative Evangelos's point, and I respect it.
Thank you. And let's see, Representative Babbage, are you complete? Yeah, okay, thank you. We'll now turn to statements from the floor. The chair will now take comments from persons attending this hearing who wish to speak for or against this nomination. Anyone who has a written statement but who does not wish to speak should have submitted the statement with the committee clerk prior to today's hearing. All such statements shall contain the name and residence of the person who prepared the statement. A copy of each written statement presented to the committee at this hearing will be made available to the nominee prior to the committee's vote, and the nominee will have the opportunity to respond to the written comment. Those who wish to speak in person registered with the committee clerk prior to the start of this hearing and will be called upon by the chairs, at which time they will be promoted to panelist status in the electronic meeting and can be seen and heard. When it is your turn to speak, please observe the following. State your name and place of residence prior to presenting your testimony. Only comments concerning the suitability of this particular nominee for this particular position will be considered in order. All other comments will be considered out of order. After you are done speaking and there are no more questions from the members, you will be returned to the attendee portion of the meeting and the next person will be called. I do want to let everybody know what the process is here. I will first call on those who wish to speak in favor and ask participants to raise their electronic hand and to keep it raised until you've been brought onto the panel to provide your testimony, because that's the only way that we can see you and recognize you. So please raise your hands if you would like to speak in support of the nomination, and leave your hand raised until you've been brought onto the panel. After we listen to those who wish to speak in favor, then we will call on those who are here to speak in opposition to follow the same process. And I see that we have 4 people in the attendee room who wish to speak. And so we will start with Jason Jabber. Welcome to the Judiciary Committee, and you may proceed.
Morning. Thank you, Senator Carney, Representative Harnett, members of the Judiciary Committee. My name is Jason Jabber, and I am the treasurer of the Maine Trial Lawyers Association. I practice law at the law firm of Jabber Liberty with our main office in Waterville. We also have an office in Portland. I'm here in Waterville. We suddenly lost our internet connection at about 9:05 a.m. So I'm on my cell phone. Hopefully the connection is okay. On behalf of the Maine Trial Lawyers Association and personally, I'm here to testify in support of the renomination of Justice William Stokes to the Maine Superior Court. The Maine Trial Lawyers Association surveyed our membership as to the candidate's skill, experience, and legal demeanor. Our executive committee considers these responses and includes their experiences and insights regarding the nominee. Today's testimony reflects the broad consensus of that process, as well as my own experience. Our survey respondents overwhelmingly praised Justice Stokes for his experience, his temperament, and his skill. Respondents to our survey called Justice Stokes a credit to the bench, smart, hardworking, on top of the issues before him, and a master of evidentiary rules. MTLA's leadership concurs in these assessments. In considering his renomination, MTLA's leadership was also drawn to the following section written by Justice Stokes in his application for renomination. And he said, "I love working with juries. I'm struggling now with the COVID-19 pandemic and what it has done to our ability to provide jury trials to litigants. Jury trials, in my opinion, are the backbone and foundation of our democratic and free way of life. I miss them now, but the many trials I have had, either as a lawyer or as a judge, continue to give me hope in our justice system." And that was taken off his application. The pandemic has challenged the justice system as a whole, and the jury particularly. Our members, along with Justice Stokes, are particularly frustrated with the challenges posed by attempting to have jury trials during these difficult times. To hear a justice speak with such devotion about the jury system, which is the single most essential element of our justice system, re-inspires us to continue to work to preserve access to justice despite the challenges imposed by the pandemic. In addition, I also want to speak briefly on a personal level in support of this renomination. I got to know Justice Stokes when I defended a homicide case that he prosecuted back in 2010. As I came into the case, I didn't know Justice Stokes. All I knew was his reputation, that as the prosecuting attorney for the Attorney General's office, I was going to be dealing with the best prosecuting trial lawyer in the state, period. My experience in dealing with him throughout the case more than confirmed his reputation. I was impressed not only with his ability, but also with his integrity and his attitude. There was a question earlier about his integrity and as it I think applied to his decisions to recuse himself from certain cases. And I would say, based on my personal experience, I was left with no question that fair and square was the only way he knew how to operate. Justice Stokes was far more experienced and a much better trial lawyer than I was, but he wasn't the least bit arrogant or condescending. He was affable and respectful, even as he litigated his side of the case with great effort and skill. The judge presiding over that case was Justice Nivison, who's now a federal magistrate judge. There's some symmetry here because I have seen many of the characteristics in Justice Stokes that made Justice Nivison such a great Maine Superior Court justice. Both were exceptional trial lawyers before taking the bench. Both are masters of the rules of evidence and are adept at managing juries. Both maintain firm control of their courtrooms while treating lawyers and litigants with respect. As John Hobson eloquently stated, and I found that his comments in these hearings typically do reflect the pulse of the legal community. He said that he's commanding but not stifling. I would extend that to say he's commanding but welcoming. And in my experience, I draw a lot of parallels with sports, and coaches have had a great influence over me. The best coaches are the coaches that you can both respect and like. And judges can strike that balance too. The best judges can. And Justice Nivison and Justice Stokes both strike that balance. In my experience, Justice Nivison is at the pinnacle of all judges, so I don't make that comparison lightly. Both are fair, practical, and efficient as they deliver justice. So in sum, based on Justice Stokes' 4 decades as a star litigator and a courtroom practitioner, the high evaluations of his service as a judge by our members, his exemplary intelligence and temperament, and his passion for the justice system, and specifically the jury system, I and the Maine Trial Lawyers Association is proud to endorse enthusiastically the renomination of Justice Stokes to the Maine Superior Court. He's everything we should want our judges to be, and his service is a benefit to our state. Thank you, and I'm available for any questions.
Thank you. Committee members, are there any questions? Not seeing any. We appreciate you being here today.
Thank you.
Next, we'll hear from Roger Cates, who is going to join us momentarily.
Good morning.
Good morning.
I'm
Welcome. You
Thank
may
you.
begin.
Thank you very much, Senator Carney and Representative Harnett and distinguished members of the Committee on Judiciary. My name is Roger Cates. I live now in Brunswick, but I practice law here in Augusta. And I'm pleased to appear before you today in full support of the reappointment of William Stokes as to the Superior Court bench. First of all, just a note of personal privilege. It was my honor to serve in the State Senate from 2010 to 2018, and I think I'm right in saying I served with 7 of you, and it's nice to see you again. Although legislators may come and go, Peggy and Susan stay, and you're very lucky for that. I've known Bill Stokes for about 40 years now, ever since he came to the Attorney General's office in 1982. He was such a standout that our law office in Augusta, at the time Lippman Cates, successfully stole him away into private practice briefly. I think he enjoyed it, but his stay with us was relatively brief because the call to return to public service was just too strong. I always thought Lippman Cates and Stokes had a nice ring to it, but it just wasn't to be. I've also known Bill from a local government because he followed me as mayor of Augusta and ran city council meetings with the same way he runs his courtroom. More on that in a minute. I think you're all very familiar now with his stellar career in the AG's office until his appointment in 2014. So he now has a 7-year track record on the court to judge his performance. I'd just like to make a few brief observations. First of all, Bill is universally liked and respected as a straight shooter by the bar, and really the entire bar. That means prosecutors, criminal defense attorneys, plaintiffs' lawyers, defense lawyers, virtually everyone. Always in chambers, and sometimes in the courtroom as well, he calls lawyers by their first names, asks them how they're doing, how their kids are, and shows a genuine interest in their lives. I'm sure he does that for a couple of reasons. One, he's a good person, but I think also it fosters a sense of camaraderie within the bar and creates an environment where people just act more civilly to one another than they might otherwise do. Second, trials are by their nature adversary in proceedings. It's the state versus someone, or client A versus client B. Usually one side or another is disappointed in the result. That's just inevitable. But what really good judges do, and what Justice Stokes does, is make sure that everyone leaves the courtroom with a feeling that the judge has treated them with respect, no matter who they are, that he has listened to them, and that he is doing the best he can as a human being to make the right decision. That's a quality that some judges have more than others, and Justice Stokes leads the list. Next, he is, I think you've heard several times now, he's just great with juries. He has a way of making them understand, as you saw here today, the critical role that they play in our system. And I think almost everybody leaves jury service proud of their contribution. I know that he does consider jury work to be the most important and rewarding part of his job. Next, he clearly loves being a judge. I think you saw that today as well, more than about anyone I have known. That comes through loud and clear. He understands when our court system works the way it should, which is not always. When it does, though, it's the best system in the world. His enthusiasm for that is infectious and virtually is picked up by lawyers, it's picked up by courtroom staff, and virtually everyone he comes into contact with. Last, Madam Chair, I want to, as a couple other people have done, I want to close with a comment that Justice Stokes himself made in his application for reappointment. And the question he was asked was, identify the most important lessons he had learned during his term. And here's what he said: patience, listening, resisting the temptation to drift back into advocacy, balancing the need to be decisive while making sure that I understand the various points of view, the importance of making timely decisions so that litigants can move forward, being respectful of them, being respectful of those in front of me whose only perception of the judiciary is me and how I behave toward them. I must be conscious of the danger of trying to rush through the daily docket and therefore fail to give a matter the attention it deserves. And that gets me back to patience. I think that sums up how Justice Stokes, in my experience, deals with being a judge. I think you get the point. The judiciary is lucky to have Justice Stokes, and I hope you'll have your unanimous support for renomination. Thank you, Madam Chair.
Thank you. Committee members, any questions for Roger Cates? I am not seeing any. Appreciate you being here today.
Thank you.
Next, we'll hear from Leonard Sharon. I think it will take just a moment for him to join the panel. Welcome, and you can go ahead with your testimony whenever you're ready.
Thank you. Good morning, Senator Carney, Representative Harnett, and honorable members of the Judiciary Committee. My name's Lenny Sharon. I'm a criminal defense lawyer from Lewiston, Maine, and I'm here. I identify myself as a criminal defense lawyer, I guess, because first of all, I was thinking back to when I testified for Bill 7 years ago, and a picture appeared in the paper of me meeting with or shaking Bill's hand after he was approved to become a member of the judiciary. And the picture read, let me just get the column. It said, William Stokes, chair of the criminal division of the Maine Office of the Attorney General, shakes hands with defense attorney Lenny Sharon after his testimony on his behalf. I identify myself as a criminal defense lawyer because the first time I spoke, that was my perspective on my opinion as to whether or not Bill Stokes would make a good justice. And I think, as Chris Babbitt said, Representative Babbitt said, you learn a lot about the integrity of a person when you compete against them. You may get beat, but you want to get beat honestly, you want to get beat ethically, and you want to get beat fairly. And that's our system of justice. And don't get me wrong, I've had cases with Bill, they're murder cases, there's a lot at stake, things get heated. Bill actually talked about or testified in a post-conviction review, something Representative Evangelos was talking about, testified about another trial he had with a prominent defense lawyer years ago in York County. And he said at points in time it became so heated, he thought he was going to get in a physical contest with the lawyer. He and I don't get into it that heatedly, but it does get into it. And you learn about it. That's where you learn about the honesty of a person when you're in a contest. I predicted then that he would be a great justice because I knew him as a person. I knew his integrity. I knew his honesty. And I knew his fairness. And that pretty much is the makeup of a judge. I'm glad to say I was right. I mean, not to pat myself on the back, but you never know how a robe's going to fit on a person. You have no idea. I mean, I always joke that just because you call some judges honorable, that doesn't necessarily mean they are. I'm not saying that's true in Maine, but it's certainly true in other parts of the country. We have a terrific judiciary here. But I would like to say that in the last 7 years, all of the qualities that a good judge is required to have, Justice Stokes has shown in spades. I had lunch with Justice Alexander, retired Justice Alexander from the Supreme Court, and tried to sell me his new book, The Maine Supreme Judicial Court and Judiciary. But when I refused to buy it, he peddled it and gave it to me, I guess. But I just wanted to read something he wrote in there. He said, as the court noted in its introduction to the new Code of Judicial Conduct in 2015 for Maine judges, the combination of the qualifications and integrity-focused judicial selection process and the significant accountability fostered by the 7-year terms has produced a judiciary that is generally well qualified and sensitive to issues of ethics, skill, and temperament that are important for fostering public respect for the judiciary. And for the bench and the bar, the close professional relations of the bench and the bar and the resulting importance of reputation foster maintenance of high ethical standards by both, supported by a prevailing assumption that judges and lawyers know each other and their reputations, and that how they act and what they say in a proceeding today can affect both that proceeding and a matter that may be of importance 5 or 10 or more years in the future. I think I'm glad I got the opportunity to testify after Roger and after hearing some of the questions from you all and after hearing Bill Stokes and Jason Jabber. Certainly from what you've heard from them, and I can attest to it as well, there's no better personification of what Justice Alexander wrote than Bill Stokes. The thing is he's just going to get better in 7 years because he's a good guy. He's an honest guy, like Roger said, and he works real hard. You know, you always think, oh man, being a judge, that's going to be, just sitting back, retired, sort of, come out on the bench, look smart. You see how hard this guy works. He works harder now on his own work than he did as an AG, producing opinions and researching opinions. We need him now more than ever. Roger touched on it. Roger Cates touched on it. Y'all touched on it. Bill Stokes touched on it. Jason touched on it. These are precarious times. And for you who sit on other legislative committees, you know how precarious it is for the criminal defense bar. Former Senator Cates knows. He sits on the committee with the court-appointed lawyers' fees that are coming up. We're struggling with jury trials. We're struggling with court-appointed lawyers. There's nobody better than Bill Stokes, this even hand, experienced hand to help us get through this. And I was thinking about what Roger said, and I'll get to the end of it in 1 second. What Roger said about walking out of his courtroom is something I was going to say as well. When you walk out of his courtroom, you just shake your head and go, that's the way a courtroom's supposed to be run. Judges call balls and strikes. They use their wisdom. And I always say, look, just don't shift the strike zone on me. And Bill Stokes would never do that. He's a great judge. He personifies. He's just terrific. And we really need him now, a guy like Bill Stokes. So I would humbly ask you to reappoint him. I would say that sitting here and listening has been going back in history. I actually represented Mr. Ardolino on a post-conviction, and I was actually the chairperson of the pardon board that gave that commutation to the woman from Hancock. So it does bring back some memories. But thank you for giving me the opportunity. I'll shut up. If you all have any questions, I'd be happy to answer it from our side of the bar. My side of the bar.
Thank you so much. Committee members, any questions? I am not seeing any. We appreciate you providing testimony today.
My pleasure.
Next, we'll hear from Frank Bishop. will take just a moment, but he will be here shortly. Welcome. You can begin when you're ready.
Hi, folks. Can everyone hear me?
Yes.
Senator Carney, Representative Harnett, and members of the Judiciary Committee, my name is Frank Bishop, and I am here in my capacity as the president of the Maine State Bar Association. I live in South Portland, Maine, and I work at the law firm of Hudson Cook LLP, which has an office in Portland, Maine. And on behalf of the Maine State Bar Association and its members, I am pleased to inform you that we fully support the nomination of Justice William R. Stokes to the Maine Superior Court. What the MSBA does is it surveys all practicing lawyers in Maine to evaluate trial court judges, usually in the 6th year of every judge's term. These evaluations are used to determine our support of or opposition of the nomination of a judge, and in turn to make recommendations on that nomination to the governor and to the Judiciary Committee. The MSBA does not take recommendations on new appointees to the bench. So you'll be hearing from me on several of the nominations later today. Justice Stokes was rated good or excellent in our surveys. The results of his evaluation show that Maine lawyers find him to be courteous, fair, kind, and respectful. He is described as intelligent, well-prepared, and thorough. Justice Stokes is commended for his knowledge of the law and well-reasoned decisions, and all those that come before him appreciate his balanced approach, which echoes many of the testimony of many of the lawyers who have come before me. Many attorneys stated that it is a pleasure to practice before Justice Stokes because of his excellent judicial temperament. So based upon the results of his evaluations, we urge the Judiciary Committee to give its unanimous support to the nomination of Justice William R. Stokes to the Maine Superior Court. I'm happy to answer any questions that anyone on the committee may have.
Thank you. Committee members, are there any questions for Frank Bishop? I am not seeing any. Thank you for providing testimony today. Next, we'll hear from William Briggio, and he's the last person who raised his hand to testify in favor of the nominee. And so I would ask those in the attendee portion of the meeting, if you're here to testify in opposition to the nominee, please raise your hand and we'll get to you momentarily. I believe that William Briggio should be here as well momentarily. Welcome, and you can begin when you're ready.
Well, good morning, Senator Carney and Representative Harnett and members of the Joint Standing Committee on the Judiciary. My name is Bill Briggio. I live here in Augusta, Maine, and until I retired last September, I served for 23 years as Augusta's city manager. I appear before you today in support of the nomination of William Stokes by Governor Mills to a second term as a Superior Court Justice. I have known Bill Stokes on both a personal and professional basis for at least 2 decades, and I hold him in the highest regard. We are neighbors and close friends, but more to the point of this hearing, we have worked collaboratively for the benefit of our community for most of the time we have known each other. That includes the years of Bill's service on the Augusta School Board, the City Council, and as our mayor, a position he held until his appointment to the bench by Governor LePage. What distinguished Bill in his community leadership roles were his high personal ethical standards, his thoughtfulness, his intelligence, and his Yankee work ethic. He balanced the demands of his job as the state's lead homicide prosecutor, respected community leader, devoted husband and father, and now proud grandfather, with poise, energy, and good humor. It's safe to say that the residents of Augusta take great pride in Bill's service over the past 7 years as a Superior Court Justice. Others can speak to the regard that the members of the bar and others who have appeared in his court hold for Bill, but I can tell you that from all of the personal interaction we've enjoyed since he became a judge, that he applies the same ethical commitment and energy every day to his current responsibilities that he did in his earlier life. On countless occasions, I have stopped by his house for one reason or another, typically in the evening or on a weekend, only to find him engrossed in researching or crafting a complex written opinion or decision with paperwork spread all over the dining room table or kitchen island, determined to get things done in a timely fashion. We have spoken many times about the deep sense of responsibility and fairness he feels he owes to all of the parties who come before him. I've poked him a few times when he says he's not free to do something because he has to be in court early by saying to him, "You're the judge. Why don't others need to conform to your schedule?" His answer is always the same, with words to the effect that too many people, courthouse staff, law enforcement officers, attorneys and their clients, jurors and others, rely on him, and that it would not be fair to them to put himself first. I think that the people of Maine are most fortunate that Justice Stokes is willing to offer his services to us all for another term, and I strongly encourage you to support his nomination with a favorable report to the Senate. Thank you. I'm happy to answer any questions.
Thank you. Committee members, are there any questions? I'm not seeing any. Thank you for providing testimony today.
Thank you, Madam Chair. And if I might just for 1 second go off script a little bit and comment that I have been overwhelmingly impressed with the COVID beard being sported by Mayor Harnett, whom I've not seen in a while. My compliments, Your Honor.
Yeah, thank you very much. And I just want to let those who are participating in viewing and watching this hearing know that we did not have anyone raise their hand to speak in opposition to the nomination. And so at this point, I will just ask once again for those in the attendee meeting, if anybody wishes to be heard on the nomination of Justice Stokes, who has not been heard, please raise your hand. And again, I am not seeing any raised hands. All public comments having been taken, the committee will now proceed as follows. We will review any additional written comments on the nomination that have been received by the committee, and we'll move on to vote on the nomination and notify the President of the Senate pursuant to 3 MRSA Section 157 and the joint rules. The vote must be taken within 40 days from the date of the governor's written notice, and we are within that time frame. The hearing by the Joint Standing Committee on Judiciary for the Honorable William Stokes of Augusta for reappointment to the Superior Court Justice is closed. In accordance with the law, the committee may not take the vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all committee members who are present agree. At this time, therefore, the chair will inquire whether any member present objects to proceeding to the vote immediately. And I see a hand up by Representative Moriarty. Go ahead, Representative.
Thank you, Madam Chair. Since 8 o'clock this morning, we all have received by email a number of comments from people who apparently are not going to testify in person. I would request that we take the 15 minutes and go off the air so that each of us can review the comments that have come in, and then we can reconvene and proceed at that point.
Thank you, Representative. And I agree with you that that is a sound recommendation in light of the arrival of new written testimony. So it is now almost 10:55. And so we will we will take a break. We will consider the written testimony that we've received this morning, and we will return at 11:10, everyone. And I would just let everybody know that the live streaming continues. And so we usually recommend that everybody turn off their audio and video until we resume at 11:10. So thank you very much, everybody. We'll see you soon. It's good morning, everyone. It is 10 past 11, and we are going to resume the confirmation hearing, excuse me. I see that it looks like all of the committee members have activated their cameras, and we are ready to move forward. The pending question before the committee is that the Joint Standing Committee on the Judiciary recommend to the Senate of the 130th Maine Legislature that the nomination of the Honorable William Stokes of Augusta for reappointment to the Superior Court as Superior Court Justice be confirmed. In accordance with 3 MRSA Chapter 6, Section 157, and with the joint rules of the 130th Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of recommending the confirmation. A vote of no will be against the motion to recommend confirmation. Is the committee ready for the question? Looks like we are. The committee clerk will call the roll, and I would just like to introduce and welcome our committee clerk, Supi Panet.
Thank you very much. It's my pleasure to call the roll. Representative Galgay Reckitt. Need to hear you, please.
Yes.
Thank you. Representative Galgay Reckitt votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Senator Sanborn. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby. I will recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Would you like me to give you the results?
I think I've got it. We had 3 absences, correct?
Yes, that is correct, Madam Chair.
Thank you. 11 members of the committee having voted in the affirmative and none in the negative, it is the vote of the Joint Standing Committee on the Judiciary that the nomination of the Honorable William Stokes of Augusta for reappointment as a Superior Court Justice be confirmed. And Justice Stokes, we typically would be coming out from around the horseshoe and shaking your hand and congratulating you, but our new tradition is a virtual round of applause. And so we'd like to congratulate you and give you a round of applause.
Thank you very much, Senator. It's very humbling. I appreciate the support.
So we appreciate your service to the state of Maine. And with that, we will conclude the hearing on the confirmation hearing on the Honorable William Stokes, and we'll move on to our next hearing.
And I'm going to leave.
Yeah, thank you.
If I can figure out a way to do it.
I can make that happen. And we'll just have a moment of transition while we bring the next nominee has already joined our panel. Welcome, Judge Cashman. We'll get started in just one moment. At this time, we will open the confirmation hearing on the Honorable Deborah Cashman. This is a public hearing of the Joint Standing Committee on the Judiciary for the purpose of considering the nomination by the Governor of the Honorable Deborah P. Cashman of West Bath for appointment as a Superior Court Justice. Under the law and the joint rules of the legislature, this committee is required to hold this public hearing and to recommend confirmation or denial of the nominee by a majority vote of the committee members present and voting. As chairs of the committee, we will then send written notice of the committee's recommendation to the President of the Senate. The committee will hear testimony from and have an opportunity to question the governor or her representative, the nominee, and any other persons present who wish to speak for or against the nomination. This meeting is currently being live streamed on the committee's YouTube channel. This means that anyone who is a participant in the meeting via Zoom can be seen and also heard if their microphone is unmuted. People testifying cannot be seen or heard until they are called upon to speak. This meeting will be recorded and available for view on the committee's YouTube channel soon after the meeting is concluded. We'll move on to the motion to confirm at this time. Pursuant to Title III, Section 157 of the Maine statutes, which require that there be an affirmative motion to recommend confirmation of the nominee, the chair recognizes Representative Lois Reckitt for the purpose of making such a motion.
I move that the Joint Standing Committee on Judiciary recommend confirmation of the Honorable Deborah P. Cashman of West Bath for appointment as a Superior Court Justice.
Is there a second? Several seconds. Thank you very much. A copy of the statutory requirements for this position is available online. The chair now recognizes Jerry Reed, counsel for the governor, for the purpose of making a statement concerning this nomination.
Thank you. Good morning, Senator Carney, Representative Harnett, members of the Judiciary Committee. My name is Jerry Reed. I'm counsel to Governor Mills, and it's my pleasure to be here this morning to present the Honorable Deborah P. Cashman as the governor's nominee for appointment to the Maine Superior Court. Judge Cashman has been a Maine District Court judge since her appointment in 2016. Since 2019, she has served as the regional scheduling judge in the Portland District Court, with responsibility for coordinating with the Superior Court scheduling justice and the county manager of court operations on the scheduling of both civil and criminal dockets in Cumberland County. In addition to the usual family law and criminal law cases that comprise the bulk of the district court's work, Judge Cashman has also presided over jury trials in the unified criminal docket. Judge Cashman is a graduate of Mount Holyoke College, double majoring in history and politics, and of the University of Maine School of Law. She began her legal career working for 4 years as a criminal defense attorney and family lawyer, primarily as a sole practitioner. She then spent 4 years as an assistant district attorney in Androscoggin and Saginaw counties. In 2012, she joined the Attorney General's office, where she served as a homicide prosecutor until her appointment to the bench in 2016. During her first term on the district court, Judge Cashman has proven to be a thoughtful, intelligent, hardworking, and fair jurist. She's deeply committed to the administration of justice. Her experience working with juries as both a trial lawyer and as a judge will be a valuable asset to the Superior Court. On behalf of the governor, I respectfully request your support for the appointment of the Honorable Deborah P. Cashman as a justice of the Maine Superior Court, and I'd be pleased to answer any questions that the committee may have of me. Thank you very much.
Thank you. The chair would ask if any member of the committee has questions for Jerry Reed. I am not seeing any. Thank you. The chair now recognizes John Hobson from Governor Mills Judicial Selection Committee. You can proceed.
Thank you very much, Senator Carney, Representative Harnett, members of the Joint Standing Committee. My name is John Hobson. I am chair of Governor Mills's Judicial Selection Committee. On behalf of the Selection Committee, I request that this committee act favorably on the nomination to the Superior Court of Judge Cashman. In evaluating Judge Cashman's performance and her whether she should be elevated and be recommended to the governor to be elevated to the Superior Court, there were a number of factors that the committee looked at. One was her background. She had a background both in defense work as a private practitioner and also extensive trial experience and jury trial experience at the Attorney General's office. And I remember when Judge Cashman was first interviewing for the position for the district court, her background seemed almost as though it fit more with the Superior Court, with the district court, because of her extensive jury trial experience. But it's always helpful to have somebody have a grounding in the People's Court, in the district court, which is really, I think, a judge who starts out on the district court gains a lot of skills in terms of docket management, in terms of dealing with pro se's. It's a hard job. And so Judge, then private citizen Cashman, was made a district court judge, nominated to be a district court judge. She was confirmed by the legislature and has served very well. As I think Mr. Reed said, that she's both hardworking and thoughtful. And I think those are, his description is absolutely right. She also comes to the elevation of the Superior Court kind of, in a sense, ready to go in terms of the Superior Court docket. And that is particularly important in these post-pandemic, well, I don't know if I can say post-pandemic times, but these hopefully transitioning to post-pandemic times, because there is going to be a point at which there are going to be jury trials, a lot of jury trials, because of the potential backlog. And her experience and her expertise in jury trials is going to be very helpful to hit the ground running in the Superior Court. And I think her having the time in the district court, and the committee felt the time that she had in the district court was very beneficial to her, for her developing an overall judicial perspective, I guess is the best way to phrase it. And that a Superior Court is almost a natural fit for her experience prior to being named as a district court judge. Therefore, on behalf of the committee, I request that this committee act favorably on the nomination of Judge Cashman to the Superior Court. I think she'll be a tremendous asset there to the people of the state of Maine, as she has been in the district court.
Thank you. The chair would ask the committee if any member has a question for John Hobson. And I am not seeing any. Thank you very much for your statement today. The chair now recognizes the Honorable Deborah P. Cashman for the purpose of making a statement concerning her nomination. Judge Cashman, you can proceed when you're ready.
Thank you, Senator Carney. Senator Carney, Representative Harnett, and distinguished members of the Standing Committee on the Judiciary. My name is Deborah Cashman, and I live in the town of West Bath, Saginaw County. It is my pleasure to be here today to discuss with you my nomination for appointment to the Superior Court. I first want to thank Governor Mills for the privilege of this opportunity and the trust that she has placed in me. I would also like to thank Attorney Hobson and Attorney Reed for their remarks here in support of my nomination this morning. Finally, I would like to take a moment to thank my husband, Matt. He is unable to be here and listen today due to work commitments, but he is here with me in spirit. Two of my daughters, Fiona and Colleen, who are a senior and a junior in high school, very much wanted to be listening here today, but they are currently taking their midterm exams and therefore unable to join. My daughter Molly, who is a sophomore at Endicott College, home on break, is currently listening along with my parents, Barbara and Bill Potter, who are listening from Woolwich. I am so grateful for the endless support that my family has given me throughout this process and my career. I first had the honor of being before this committee in March of 2016 when I was nominated to be a judge on the Maine District Court. As much of the membership of the committee has changed since I was here last, I will begin by telling you a bit about myself. And some of this you may have just heard from Attorney Reed, but I will continue. I grew up in Woolwich, where I attended the Woolwich Central School, and then went to Morse High School, where both myself, my father, my grandfather, and now my children have all attended. I left Maine to attend Mount Holyoke College in South Hadley, Massachusetts. And although I initially thought that I wanted to attend law school out of state and try life in a big city, in the spring of my senior year, I reconsidered and decided to return home to Maine, where I attended the University of Maine School of Law. I have never once regretted that decision. I love living in Maine, raising my family here, and serving the people of Maine as an attorney, a public prosecutor, and now as a judge. I began my legal career in 1994 as a criminal defense attorney, working first in a small firm in Auburn, and then as a solo practitioner in the Lewiston Auburn legal community. In addition to criminal defense, I expanded my practice to include representing parents in child protective cases and serving as a guardian ad litem. I found this work to be extremely rewarding. I took seriously the responsibility of representing individuals who were facing difficult circumstances in their lives, and I worked each day to assist them. Running a solo practice, however, was not without its challenges. I recently listened to the MCILS Attorney Forum, and I reflected on and empathized with the difficulties that the attorneys are experiencing today. In 1998, I closed my practice and began working as an assistant district attorney in Androscoggin County. I served as a prosecutor for almost 18 years, 14 years as an assistant district attorney in Androscoggin, then Saginaw and Lincoln counties, and for 4 years as an assistant attorney general in the criminal division. Throughout my years as an ADA, I focused primarily on sexual assault and sexual exploitation cases. In 2012, when I began working for the Attorney General's office, I represented the state of Maine in homicide cases. Throughout my time as a prosecutor, I worked on cases involving vulnerable witnesses, such as children, adults who experienced sexual and domestic violence, and families whose loved ones had been killed. In April of 2016, I had the great honor of becoming a judge on the Maine District Court. I began my time on the bench in York County in the Biddeford and Springville District Courts, as well as the Unified Criminal Docket, which was held in Alfred. In 2018, I moved to the Portland District Court, where I sit today. In addition to my regular trial work, for the past 2 years, I have also served as the regional scheduling judge, working with my Superior Court counterpart and the regional court manager in the scheduling of the Cumberland County dockets. As this committee is acutely aware, scheduling in the time of COVID has proven to be a very difficult and daunting task, attempting to ensure that citizens are able to safely and expeditiously have their legal matters addressed. The last 2 years have presented the Maine courts, like so many other organizations and businesses, with unprecedented challenges. Addressing the backlog of cases that grew as a result of the pandemic is a daily responsibility. We continue to strive for new approaches that allow litigants to appear in court to have their matters addressed, even if they are not able to come to the court in person. We have greatly expanded our capacity to hold virtual court through Zoom appearances and telephonic conferences. This remote process has allowed individuals to appear for their court hearings who might not otherwise have been able to do so. We have also expanded our virtual capacity in an effort to address the strain on the rostered court-appointed attorneys in Maine, allowing attorneys to appear in Portland on 1 minute and then to appear in another court or courts throughout the state the next. This has been an invaluable resource, especially at a time when our court-appointed attorney roster has shrunk. As a scheduling judge, I am constantly evaluating and reevaluating how our processes are working and where there can be changes. We regularly hold bench bar meetings and stakeholder meetings with attorneys from the various dockets to hear what the practitioners find to be working and what areas can be improved upon. These new approaches will undoubtedly continue post-pandemic to ensure access to justice throughout Maine. As a judge in the district court, I spend much of my time presiding over the child protective docket, alternating monthly with another district court judge, as well as the family court docket. I have also had the privilege of serving on the unified criminal docket. During my time in the UCD, I have presided over a number of criminal jury trials. I believe ensuring that every litigant before me has the opportunity to be fully heard is one of my most important responsibilities. Many of the people who appear in the district court do not have the benefit of counsel. Many do not fully understand the process and the rules of court that a judge is bound to follow. As a judge, I cannot assist or help a litigant, but I do make every effort to ensure that the litigant understands the process of the hearing he or she is about to have. I must be open-minded, scrupulously fair, patient, and compassionate to those individuals before me. I strive to treat everyone, litigants and attorneys alike, with respect, regardless of what brings them to court. It is these same qualities that will continue to serve me if I'm given the opportunity to be a justice on the Maine Superior Court. I have spent the majority of my career in the Superior Court. I have had numerous jury trials, both as a criminal defense attorney and as a prosecutor. I have presided over several criminal jury trials as a judge. Prior to joining the bench, I served on the Criminal Rules Committee. Now I am a member of the Jury Management Standing Committee, and I am the Chief Justice's judicial designee on the Maine Commission on Domestic Abuse and on the Domestic Abuse Homicide Review Panel. These experiences and my familiarity with the jury trial process will be an invaluable resource to me on the Superior Court. Throughout my career, I've acted with integrity, humility, and have approached each new challenge enthusiastically and fully prepared to address whatever new issues are presented. It is my hope that I may continue to serve the people of Maine in this new role as a Superior Court Justice. Thank you for this opportunity to address you and for your consideration. I'm happy to answer any questions that you may have for me.
Thank you very much, Judge Cashman. And it looks like we do have questions. So at this point, committee members, if you have questions, please raise your electronic hand and leave it up until I reach you. And we'll begin with a question from Representative Reckett.
Good morning.
Morning. I read your materials with interest, and I want to thank you for the years of service you've already given. I also noticed that you were on the Commission on Domestic Abuse and the Homicide Review Panel, both of which I served on for years myself. And so I'm familiar with how difficult some of those sessions are to listen to and be part of. I also noticed really that your continuing legal education and a variety of other things pointed to me an emphasis in your, if not your, well, in your practice, I guess, of paying careful and close attention to both domestic violence and sexual assault issues, for which I think is a wonderful thing. My question is why? I mean, what drew you to that area of the law? Is there was there some piece of your experience or your legal experience that drew you to that those topics?
When I was a young district attorney, I can't say that as a defense attorney, I represented many individuals charged with that. I think that was just the nature of the cases that I received on appointment. But when I was young in the DA's office, I had the opportunity to sort of see an area of cases that I thought was being underserved. I think in order to prepare those cases properly, there needs to be time and consideration given to really understanding the circumstances of the person who is coming forth saying that they were a victim of that particular type of crime. And so it was something that caught my attention as an area that I thought needed some attention. I had a boss, I worked for a district attorney who gave me the opportunity to sort of really dig in, learn that area. I learned the case law, I learned how to present the evidence. As you can see from my continuing education, I learned the different types of evidence. And so I sort of grew through that. And the majority of my work was in the sexual violence. Domestic violence, we had a separate designated domestic violence prosecutor, so I didn't have the opportunity to really focus on that initially. But of course, much of the sexual assault cases also involved allegations of domestic violence. And then so that continued to be an area of interest to me and something that I I volunteered in certain things to make sure that the process was fair and people had an opportunity to be heard. That's something that's important to me in all my cases. And I think in that, those voices sometimes aren't heard. So I worked very hard towards that.
Thank you very much. Madam Chair, if I have just one quick question of curiosity.
Go ahead.
As I was reading about your activities and noticed that you were on the JUD Inn of Court. What in the world is that?
It's a professional legal organization. And I have to say that in the time of COVID, I haven't been as active as I probably should be. They continue to meet remotely. But what it is once a month, the attorneys in Cumberland County meet. There's an element of continuing education. There is the camaraderie of meeting with people who you might not see. And it's a very nice function.
So was Judge JUD. That's what triggered my curiosity about it. Thank you very much.
Thank you.
Representative Thorne, you can go ahead with your question.
Thank you, Madam Chair. Welcome, Justice Castman. Appreciate you being here today, and I'm sure you appreciate being here as well.
Absolutely.
My question is, in today's atmosphere of social media, this is often asked, but if you could give up your humility for a moment and let us know, two-part question, what personal attribute and professional attributes have gotten you here to this position today?
Thank you for that question. I would say that for myself, preparedness is probably the personal and sort of has seeped into my professional attribute in that I always want to be as prepared as I can, whether it's understanding the case, understanding who's going to be before me. As a judge, I read all the files before I go into the courtroom. The few times when something has happened where I had to quickly grab the file, I find that you're not doing your job well if you aren't prepared. And so preparedness is certainly an attribute of mine. Some would say I obsessively prepare, and maybe to a fault sometimes. Professionally, I think organization, making sure that I know what is going to happen, and being able to be there fully for the people before me, because they look to the court to sort of make them feel like they are being heard and that justice is happening. And so I think that is professionally my organizational skills.
Thank you for helping us understand you a little better, and good luck to you.
Thank you.
Thank you, Madam Chair.
Representative Harnett.
Thank you, Madam Chair, and welcome, Judge Cashman. Looking at your resume and experience, you've served both as a criminal defense attorney and a prosecutor. Do you think having seen both sides of that practice has influenced you as a judge or made you better equipped to deal with criminal cases in front of you? And if so, how?
Absolutely. Having walked in the shoes of the people who are in front of you, and I'm talking with the practitioners now, it can allow you to understand what they're going through. I also, when I was doing, it's not the criminal work, but when I did child protective, I represented a lot of parents who were really struggling. And I had an ability and a patience to take them where they were, to sort of strip off the frustration or the hostility that they may be happening, and sort of try to really dig into what they're trying to get across. And I find that I have the ability to do that in district court. We deal with many people who are not represented. And so some people will come in, they can be very frustrated, they can be confused by the process. And I try to sort of remove that so that I can hear what they're saying, rather than sort of being initially off-put by their immediate reaction. Or some may find that they're being disrespectful, for example. And I think that my time doing criminal defense work, representing parents in child protective cases, and honestly, my time as a prosecutor working with many of the victims, people present in ways that may not initially allow for you to hear what they're saying. And so I think that's something that I strive very hard to try to understand and accept people where they are when they're before me.
Thank you, Judge Cashman. Could I have a quick follow-up, Madam Chair?
Yes.
Judge Cashman, when you were doing criminal defense and child protective work, were you a rostered attorney on MCILS at any time?
MCILS did not exist at the time. I was a court-appointed attorney, and I think we had to sign up with something, but the court was making the appointments at the time. They would review our vouchers. And so that process, the commission came into being after I left the defense work. But the vouchers, a lot of the constraints that I heard about on the forum, the disproportionate, like I had to pay for all of my own continuing education, for example. All of those things were very similar to now, but we didn't have the structure of the commission.
Thank you very much.
Is there any other committee member who has a question for Judge Cashman? Not seeing any, but I did have a question for you, Judge Cashman. It sounds like you are really integrally involved with the kind of operational aspects at the district court level. And I was wondering if you could provide us with a little bit more information about how you value the opportunity to do that work, and whether you anticipate being involved in that level at the Superior Court level.
The regional scheduling judge is something that's in addition to your trial work. There is an administrative aspect, but I am a trial judge. I am not a fully administrative body. But I do of course, we have a very large backlog in Cumberland County. We have, and frankly, before COVID, I don't think I really appreciated the numbers of cases, particularly on the criminal level, that came through our court. I knew our dockets were busy. And now with the inability to sort of move some of the cases through the process, either through jury trial or other resolution, I've sort of seen that expand. So I'm not sure that I would initially be a regional scheduling judge as a Superior Court justice, because usually that's someone who has been on the bench for a bit of time. I will be a new person if I get this honor. But I certainly know that my experience in hearing the attorneys and trying to brainstorm, it's a tension trying to not overload the attorneys by pushing the cases through, while at the same time allowing the docket to proceed and have some of the cases resolve. And so I think the work that I've done in that and the constant meetings and all of that will certainly serve me as a jurist in helping people resolve cases.
Thank you.
Thank you.
Representative Harnett, did you have an additional question?
I did not. I will lower that hand. Thank you.
Okay, thanks. Committee members, I'm looking to see if anyone has additional questions for Judge Cashman. And I am not seeing any. Thank you so much for being here today, for your service to the people of Maine, and for your statement.
Thank you.
The chair will now take comments from persons attending this meeting who wish to speak for or against this nomination. Anyone who has a written statement but who does not wish to speak should have submitted the statement with the committee clerk prior to today's hearing. All such statements shall contain the name and residence of the person who prepared the statement. A copy of each written statement presented to the committee at this hearing will be made available to the nominee prior to the committee's vote, and the nominee will have an opportunity to respond to written comment. For those who wish to speak in person, you have registered with the committee clerk prior to the start of this hearing so that you could receive a link to participate, and you will be called upon by the chairs, at which time you'll be promoted to the panelist status in the electronic meeting and can be seen and heard. When it is your turn to speak, please observe the following. State your name and place of residence before presenting your testimony. Only comments concerning the suitability of this nominee for this particular position will be considered in order. All other comments will be considered out of order. After you are done speaking and there are no more questions from the members of the committee, you'll be returned to the attendee portion of the meeting and the next person will be called on. At this time, I would look to those who are in the attendee portion of the meeting and ask anyone who wishes to speak in support of this nominee to please raise your electronic hand and to please leave it raised until you've been brought onto the panel to provide your statement. And we have a number of people who wish to speak for the nominee. And so we'll begin with Laurie Boxer-Makeover. It always takes a moment for people to move through cyberspace, so she will be joining us shortly. Welcome to the committee, and you can begin your remarks when you're ready. And we're not able to hear you. We still aren't able to hear you. I think you. There you go.
Okay, sorry about that. You'd think after 2 years. Good morning. My name is Laurie Boxer-Macomber. I'm president of the Maine Trial Lawyers Association, and I'm here to testify in support of the nomination of Judge Cashman for a Superior Court judge role. You probably have already heard this morning from Jason Jabber about the procedures that our organization uses to review nominees, and you've heard about them in the past legislative sessions as well. But briefly, we survey our membership, and we're looking to hear from people on anything that raises any type of concern about ethical issues or conduct, as well as to hear about the strengths and weaknesses of candidates. In this case, Judge Cashman was unanimously rated favorably for her experience, temperament, and skill. Respondents in the survey for this year called her an excellent selection. We also looked at our prior surveys to make sure there wasn't anything that we were missing. And when we looked back at those, her competence and ability to fulfill a judicial position was called out. So I did want to just briefly echo a couple of the things that I heard earlier today and the importance for trial attorneys, since that's what I'm here to testify on. One is Judge Cashman's experience with scheduling. As those of you who are attorneys that sit on this committee may know, when you go to law school and you take the LSAT, or before you go to law school, there are all these questions that have to do with they're like strategic questions about who can sit next to whom and at a dinner party, and you have to figure out all of these little silly details and report back on what the best answer would be, and make these different arrangements work. And so a lot of people may not think having scheduling experience is crucial to a judicial position, but right now, particularly during a time when the courts are so backlogged, hearing that Judge Cashman has that is going to be very useful and very important to the Superior Court. So that's something that's critical for us. And likewise, someone who's already been in the court for a considerable period of time is going to be an asset on the Superior Court, which is going to have a heck of a lot to deal with when it comes to civil and criminal backlog. So we are in favor of Judge Cashman for those reasons in particular. We believe she's going to be an asset to the courts, and we highly recommend that you endorse her. Thanks.
Thank you. Committee members, are there any questions? I'm not seeing any.
Thank you for your time and service, everyone.
Next, we'll hear from Lise Wagner. Welcome to the Judiciary Committee, and you can begin with your statement whenever you're ready.
Good morning, I think still, yes. Senator Carney, Representative Harnett, and members of the Judiciary Committee. I am Lisa Wagner. I live in Portland, Maine, and for the past 25 years, I have represented the Department of Health and Human Services as an Assistant Attorney General in child protective cases. I am honored to be here in my personal capacity to speak on behalf of Judge Deborah Cashman. I have known Judge Cashman since we were both in law school, but most recently I've appeared in front of her for the last 2 years as she has shared the child protective docket in Portland. Judge Cashman took over this caseload when COVID began. As I'm sure you're aware, Portland has a very heavy docket. We finished 2021 with 95 new cases filed and had 91 in 2020. In addition to being the regional scheduling judge, as you've heard, Judge Cashman had to quickly adapt to court going remote, the wonders of Zoom, electronic filings, being in person for some, virtual for others. I could go on. It has been an interesting 2 years, to say the least. Through it all, Judge Cashman has maintained a calm demeanor and has worked hard to try to be as accommodating as possible while still creating a clear record in our cases. I am not sure what phases Judge Cashman, other than perhaps someone appearing in court remotely while in bed, or eating lunch, or smoking, or the time I had to ask for a brief recess to remove a bird from my cat's mouth. No, Not even that did much but cause her to merely remark that life certainly does go on outside of the courtroom. Judge Cashman has excellent judicial temperament. She is firm, clear, and kind, particularly in protective custody cases with people who are under a great deal of stress. She expertly rules on evidentiary issues, and she has a good knowledge of child protective case law. Her many years of experience as a judge in family court has been very helpful when there is an overlap of family matters with protective custody cases. Judge Cashman has held multiple bench bar meetings for child protective attorneys, assistant attorneys general, and guardians ad litem to hear concerns about practicing during COVID. She's been open to and has implemented changes to keep us safe and to make the process work smoothly. She respects the work that we do. It is also very clear that she cares about her colleagues and the court personnel with whom she works. I am actually familiar with one other district court judge who is not happy that she's been nominated to Superior Court. Judge Woodman would like her to stay on the district court, but we'll see that you do the right thing. It has been an honor to appear before Judge Cashman. I support her nomination to the Superior Court, even though it means I will no longer have the pleasure of being in front of her. I wish her well. I would be happy to answer any questions that would be helpful to the committee.
Thank you very much. Committee members, are there any questions for Lisa Wagner? Not seeing any. We appreciate you providing a statement today.
Thank you very much.
Next, we'll hear from Frank Bishop. Thank you for joining us again, and you may proceed with your statement whenever you're ready.
Thank you, Senator Carney, Representative Harnett, and members of the Judiciary Committee. Again, my name is Frank Bishop, and I am here in my capacity as president of the Maine State Bar Association. I live in South Portland, and I practice in an office here in Portland, Maine. On behalf of the Maine State Bar Association and its members, I am pleased to inform you that the association fully supports the nomination of Judge Deborah P. Cashman to the Maine Superior Court. Just in case there were folks who missed my brief explanation of our process earlier, we do send out surveys to all practicing lawyers in Maine for the purpose of evaluating trial court judges, generally in the 6th year of every judge's term. These evaluations are used to determine whether or not we will support the nomination of a judge, and in turn make recommendations on that nomination to the governor and the Judiciary Committee. In summary, Judge Cashman's evaluations were excellent. Attorneys describe her as decisive yet patient and even-tempered. She is also described as thorough, efficient, intelligent, and adept at maintaining control of her courtroom. Judge Cashman is commended for her firm understanding of substantive case law, and she makes well-reasoned decisions based on this knowledge. These traits have earned Judge Cashman the support and respect of MSBA members, and Maine citizens will benefit from her continued service on the bench and her move to the Maine Superior Court. So with that, the Maine State Bar Association urges the Judiciary Committee to give its unanimous support to the nomination of Judge Deborah P. Cashman to the Maine Superior Court. I'm happy to answer any questions that members of the committee might have.
Thank you very much. Committee members, are there any questions for Frank Bishop? I am not seeing any. We appreciate you providing a statement today. And next we will hear from Jeffrey Silverstein.
Good morning.
Good morning. Welcome to the Judiciary Committee, and you can begin your statement when you're comfortable.
Thank you, Senator Carney, Representative Harnett, and committee members. My name is Jeff Silverstein, and I'm pleased to appear before you and speak on behalf of Judge Deborah Cashman. Some of you folks probably don't know me. I'm a Bangor defense attorney. I've operated and worked essentially solo since 2005. Prior to that, I was associated with Hillary Billings, and we had a partnership for almost 10 years. Prior to that, I was an assistant district attorney for 6. And prior to that, back in 1990, when I started my career, I was a judicial law clerk for the Superior Court justices north of Augusta. And although none of them remain on the bar now, I had access to and worked very, very closely with probably 6 or 8 at the time. Following that, I took a job as an assistant district attorney. And because I was essentially quote unquote in with the Superior Court judges and a known quantity, I started a Superior Court based district attorney related practice almost immediately, and commenced with trying felony level jury trials and doing all the motion work, as well as handling all the office's appeals. In 1996, I left and started private practice. And since then, I have, probably largely due to the relationship I had with the Superior Court justices at the time, developed a very busy homicide defense practice. And since 1998, I've done in excess of 50 of these homicides, mostly murder cases coming through the Attorney General's office, but many manslaughter cases worked on by assistant district attorneys and DA's offices as well. In addition to my litigation experience, I've also spent approximately 12 years on the advisory committee for the criminal rules. As well, I spent 10 years on the main board of bar examiners and entering my 3rd season as a CLAC member. So with all that, I've had a lot of experience to Superior Court justices, and as well to litigants who practice before the Superior Court. And I think my experience leads me to conclude that there are some traits, if you will, or factors that make for a successful Superior Court justice. And those, I believe, include the following: patience, as well as being neutral and non-biased, to have a wide knowledge base and a high degree of intellect, to have a degree of confidence that you portray to the public, but as well to be personable and approachable. And I found that all of the well-liked and well-regarded and successful Superior Court justices that I have worked with over the many, many years I've been doing this have shared those traits. And I find that Judge Cashman as well shares those traits. Now, being a litigant in Bangor, I cannot say that I have practiced before her since her ascension to the district court bench, as she has sat downstate, and my practice doesn't take me before district court judges on those kind of cases downstate. Nevertheless, she and I had experience working together prior to her appointment to the district court. There had been, back in and around 2012 or thereabouts, a triple murder that occurred up in the Bangor area. And the facts and circumstances were such that there was not the typical wealth of evidence that the Attorney General looks for in order to pursue those cases. And this presented as an extremely difficult and challenging case to present, as it relied substantially on electronic communications and, how shall I say, the resurrection, if you will, or recreation, tracing footsteps through electronic means. And it required a significant amount of work through expert witnesses, both who were skilled and knowledgeable in that capacity, as well as all of the issues presented through the prosecution of these homicide cases. This was a very, very noteworthy case because these cases happen, fortunately, very, very rarely in the state of Maine. So all eyes in the state were on this case. It took us approximately 3+ weeks to try to completion. The better part of 2 weeks was spent actually trying the case. And then the better part of an additional week was spent awaiting a verdict. I think it presented as the longest case of juror deliberations that the state has experienced to date. As a result of that, or I should say, during the process of the presentation of that case, and you folks may know it as the Randall DeLuz and Sexton case. DeLuz and Sexton were the last names of the defendants. Nevertheless, Ms. Deborah here was one of the lead prosecutors on the case, and she presented to the courthouse on a daily basis, possessing many of those attributes that I indicated earlier as having been shared by successful Superior Court justices. She presented with a firm grasp of the very, very complicated material that we were dealing with. She presented as knowledgeable with the rules of evidence, as having done her homework and being fully prepared with all of those various matters. She presented as very, very pleasant. And some of you may know, as these type of cases wind on day after day after day, they tend to, have emotional highs and lows shared by those participating. But she presented with the best of attitudes and the most pleasant of perspectives the entire time. She was most respectful towards all involved, not only the court staff and court personnel, but also of the various witnesses that she was dealing with, both presented by the state and presented by the defense. And as well, we were dealing with one particular attorney who was very vexing and challenging in terms of his presentation. And the kind of fellow who could get under your skin and cause you to do things that one may not have expected when they arose in the morning, just as emotional responses to difficult situations. But Ms. Cashman kept herself together, kept her excellent perspective and most positive approach as having ruled the day. And she just was the most pleasant, courteous, and respectful individual in that regard. So over the course of this 3-week period, I certainly had access to Ms. Cashman under circumstances of great stress that was placed upon us, not only by the process, but also by the presentation. And these matters are stressful affairs. And I just noted that she negotiated herself with the highest regard and highest esteem. And so when she came up for district court nomination, I was very, very not only proud and pleased for her, but confident she would do well, though I thought at the time that the nomination was misplaced, as she would be more appropriately placed given her experience on the Superior Court. So with all that said, with the many, many years of Superior Court experience I've had, I think she will make an excellent fit as a Superior Court justice. And we'll look forward, if she hits the road and heads up north, to making any appearances before her as may be arranged or scheduled. With all that said, I was grateful to be asked to speak on her behalf, and I am happy to field any questions any committee member may have. Thank you.
Thank you for your statement, Jeffrey Silverstein. Committee members, any questions? I am not seeing any. We appreciate you being here today.
Thank you.
And I'll turn once again to the attendee portion of the meeting and ask if there's anyone in attendance who wishes to speak in support of this nomination. I do not see any additional people. Is there anyone who wishes to speak in opposition to this nomination? And again, I do not see anyone. We'll move Mr. Silverstein back to the attendee part of the meeting. All public comments having been taken, the committee will now proceed as follows. Review any additional written comments on the nomination that have been received by the committee, and vote on the nomination and notify the President of the Senate pursuant to Title III, Section 157 of the Maine statutes and the joint rules. The vote must be taken within 40 days of the date of the governor's written notice. The hearing by the Joint Standing Committee of the Judiciary for the Honorable Deborah P. Cashman of West Bath for appointment as a Superior Court Justice is now closed. We will move on to taking of the vote. In accordance with the law, the committee may not take the vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all committee members who are present agree. At this time, therefore, the chair will inquire whether any member present objects to proceeding to the vote immediately. I know that we had an opportunity and a 15-minute break to review written testimony at our last hearing. Is there any committee member who wishes to have a 15-minute break at this time? I am not seeing any. There is no objection. And so the pending question before the committee is that the Joint Standing Committee on the Judiciary recommend to the Senate of the 130th Maine Legislature that the nomination of the Honorable Deborah P. Cashman of West Bath for appointment to the Superior Court, appointment, as a Superior Court Justice be confirmed. In accordance with 3 MRSA Chapter 6, Section 157, and with the joint rules of the 130th Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of recommending the nomination. A vote of no will be against the recommended nomination. Is the committee ready for the vote? And it appears that we are, and so the committee clerk has joined us and will take the roll.
Thank you, Madam Chair. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Senator Keim. Senator Sanborn. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby. I will recall the absentees. Senator Keim. Senator Keim is absent. Senator Sanborn. Senator Sanborn is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. That is everybody, Madam Chair.
Thank you very much, Ms. Panett. 10 members of the committee having voted in the affirmative and no members of the committee in the negative. It is the vote of the Joint Standing Committee on the Judiciary that the nomination of the Honorable Deborah P. Cashman of West Bath for appointment as a Superior Court Justice be confirmed. Justice Cashman, we ordinarily would be shaking your hand and offering in-person congratulations, but at this point, we extend our congratulations and we will show that with a virtual round of applause.
Thank you all very much. It was a pleasure to be here. Thank you.
Thank you so much for your service to Maine, and we appreciate your willingness to serve as a Superior Court Justice. And with that, the hearing is closed. Our work for this morning is concluded. We will resume at 1 o'clock for a series of 3 additional confirmation hearings on transition of members to an active retired justice position. So we will see everyone at 1 o'clock. Thank you.
Good afternoon, Justice Warren. How are you? Good afternoon, all. We're just waiting for committee members to return from lunch. We'll start up as close to 1 o'clock as we can. Welcome, Justice Warren.
Thank you.
Nice to see you again.
Nice to see you.
How is Andrew?
He's fine to the extent we hear anything. He's down in Boston. I'm not sure exactly what he's planning to do from here, but he seems happy, so that's the good news.
You'll be the last to know. Don't worry.
I think that's right. How's your daughter doing?
Both Eloise and Joe live in Manhattan. We have a younger son, Joey.
Right.
But Eloise is, they're doing great.
Good.
That everybody in the world has COVID down there, other than.
Oh, a lot of people up here as well.
Yes. We're getting there. Just to those arriving, we're going to wait for a couple more committee members. It's still a little before 1. And we're never known to start early. So I think that's against legislative rules. And if I could ask Soupy, are we live already? Are we on Zoom? Okay.
It looks like it to me.
How can you, oh, is that the green check mark?
Well, it's the left live up there in the left-hand corner
I don't see that.
of my screen, so I don't know.
Yep, I have the same.
Different computers show different things.
Mm-hmm.
We are streaming on YouTube. Thank you, Peggy. I'm just going to wait for my Senate co-chair. Okay, we have been joined by committee members and my Senate co-chair, Ann Carney. Welcome, Senator Ann Carney, to welcome to the afternoon hearing of the Judiciary Committee for January 18th. We will be hearing 3 confirmation proceedings for movement of a Superior Court justice to active retired status and 2 district court judges to active retired status. Because we are beginning after a break, I will have committee members introduce themselves. I will call on you in the order that I see you on my screen, starting with Representative Thorne.
Thank you, Mr. Chair. Good afternoon. My name is Representative Jim Thorne. I represent House District 103, which is Carmel, Herman, and a portion of Etna up in Penobscot County.
Thank you, Representative Thorne. You were moving it a little further north there. Representative Evangelos.
Thank you, Mr. Chair. Representative Jeffrey Evangelos, House District 91, and I reside in Friendship.
Thank you, Representative Poirier.
Thank you, Mr. Chair. I'm Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Thank you. And Representative Sheehan.
Thank you, Mr. Chair. My name is Erin Sheehan, and I represent House District 12, which is downtown Biddeford.
Thank you, Representative Newell.
Thank you, Mr. Chair. My name is Rena Newell, and I represent the Passamaquoddy tribe.
You, Representative Moriarty.
Thank you, Mr. Chair. I'm Steve Moriarty. I represent Cumberland and the southern part of Bray.
Thank you, Representative Galgay Reckett.
Afternoon. My name is Lois Reckett, and I represent District 31, which is the ocean end of South Portland.
Thank you. And Representative Babbage.
Good afternoon. My name is Christopher Babbage. I represent the town of Kennebunk, although technically just the 82% of citizens that reside in District 8.
Thank you. And last but not least, my Senate co-chair, Senator Carney.
Good afternoon, everyone. I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, where I reside, and a little tiny bit of Scarborough. It's nice to see you all.
Thank you. And I want to acknowledge the people who actually make this process go, and that is our OPLA analyst, Peggy Reinsch, who is here with us today, and also our committee clerk, Supi Panett. Thank you for all that you do. And with that, this is a public hearing of the Joint Standing Committee on Judiciary for the purpose of considering the nomination by the Governor of the Honorable Thomas D. Warren of Portland for appointment as an active retired justice of the Superior Court. Under the law and joint rules of the legislature, this committee is required to hold this public hearing and to recommend confirmation or denial of the nominee by majority vote of the committee members present and voting. As chairs of the committee, Senator Carney and I will then send written notice of the committee's recommendations to the President of the Senate. The committee will hear testimony from and have the opportunity to question the governor or her representative, the nominee, and any other persons present who wish to speak for or against the nomination. This meeting is currently being live streamed on the committee's YouTube channel. This means that anyone who is a participant in the meeting via Zoom can be seen and also heard if their microphone is unmuted. People testifying cannot be seen or heard until they are called upon to speak. This meeting will be recorded and available to view on the committee's YouTube channel shortly after the meeting has concluded. Now proceed with a motion to confirm. Pursuant to Title III, Section 157 of the Maine statutes, which requires that there be an affirmative motion to recommend confirmation of the nominee, the chair recognizes Senator Ann Carney for the purpose of making such a motion.
I move that the Joint Standing Committee on Judiciary recommend the confirmation of the Honorable Thomas D. Warren of Portland as for appointment as an active retired justice of the Superior Court.
Thank you, Senator Carney. Do I have a second? Seconded by Representative Sheehan. A copy of the statutory requirements for this position is available and accessible online. At this point, the chair now recognizes Representative of Governor Janet T. Mills Jerry Reed for the purpose of making a statement concerning this nomination. Mr. Reed.
Thank you. Good afternoon, Senator Carney, Representative Harnett, members of the Judiciary Committee. My name is Jerry Reed. I'm counsel to Governor Mills, and it's my pleasure to be here today to present the Honorable Thomas D. Warren, who is retiring from active status on January 31st as the governor's nominee for appointment as active retired justice of the Maine Superior Court. Justice Warren was appointed to the Superior Court by Governor Angus King in 1998 and has served with great distinction. He began his legal career working in private practice in New York for 3 years and then served for 6 years as an assistant United States attorney in the Southern District of New York, quickly rising to the prestigious position of chief appellate attorney in that office. He then worked for 14 years in the Maine Attorney General's office, 10 of which were spent as Deputy Attorney General and Chief of the Litigation Division, and the last 2 of which were also spent as State Solicitor. Justice Warren is a graduate of Yale College and Harvard Law School. During his tenure on the Superior Court, Justice Warren has served on numerous committees and advisory groups, including most recently as the chair of the Jury Management Group and alternate Superior Court representative on the Committee on Judicial Conduct. He has also served on the Judicial Education and Civil Rules Advisory Committees. I was fortunate to overlap with Justice Warren for several years when he was with the Attorney General's office. And like many others, I learned a lot from him, both directly and from observing him in action. He was the standard bearer for excellence in lawyering in that office and deeply admired for his knowledge of the law, his exceptional intellect, his commitment to the highest ethical standards, and his willingness to speak truth to power. That reputation has only expanded and solidified since his appointment to the bench, where he has been one of the leading lights of the Maine judiciary. The state has benefited greatly from Justice Warren's decades of public service here, and we would be fortunate to retain him in the capacity of an active retired justice. On behalf of the governor, I respectfully request your support for the appointment of the Honorable Thomas D. Warren as active retired justice of the Maine Superior Court. Thank you, and I'd be happy to answer any questions the committee may have of me.
Thank you very much, Mr. Reed, for bringing this nomination forward today. Are there any questions from committee members for the Governor's Council, Mr. Reed? Seeing none, I will now turn to John Hobson, who chairs the Judicial Selection Committee, for a statement on behalf of the nominee. Welcome, Mr. Hobson.
Thank you very much, Representative Harnett, Senator Carney, members of the Joint Standing Committee on the Judiciary. My name is John Hobson, and I am chair of Governor Mills's Judicial Selection Committee. On behalf of the Selection Committee, I request that this committee act favorably on the nomination of Justice Warren to become an active retired judge. Judge Warren has, for a long time, as Mr. Reed said, kind of set the standard for intellectual excellence and for the ability to grasp an issue and synthesize the issue very quickly. And he's someone who, despite his candidly intellectual brilliance at times, is very down to earth. He's somebody who is very approachable and someone who a jury feels very comfortable with. He's somebody who really is able to go between those two worlds, the worlds of really, high intellectual achievement and still be able to relate to and interact with people from every walks of life. He's been a huge benefit to the judicial branch in the state of Maine, as his public service was before to the state. And it would be a huge loss if we were not to have Judge Warren on the bench any longer. Fortunately, he's not retiring and just fading away into the sunset. He is willing to stay on as active retired, and candidly, one of the job categories is probably the biggest bargain to the state of Maine is the active retired status for judge. But is willing to serve as an active retired judge and continue service to the state of Maine, and that is a huge benefit both to the litigants and the lawyers in the state and the overall citizens. And so on behalf of the Judicial Selection Committee, I requested this committee act favorably and take up Judge Warren on his offer before he rethinks it.
Thank you very much, Mr. Hobson. And I've been informed that even though I'm in the state complex, that I might be breaking up a little. If I disappear, my able co-chair will jump in. I tried to shut down all unnecessary windows here. But thank you for that statement, Mr. Hobson. Are there any questions from committee members for Mr. Hobson? Representative Moriarty.
Thank you, Mr. Chair. Mr. Hobson, as you know, we don't have any representatives from the Judicial Department participating in these hearings, so I'll just run this by you. All three of our nominations this afternoon involve the transition from active to inactive status. And so in light of the backlog and all the consequences of COVID, are you able to tell us what the department expects of an active retired judgment in this new era? Are they likely to be called upon more frequently and more regularly than in the past?
I think that's likely, although I certainly can't speak for the judicial branch. And I think it's probably still a determination in process, so to speak, because we're still not out of the pandemic. But when we get to the point where we're able to have jury trials without the kind of restrictions that we're under now, the way to chip away at the backlog is to have large trial lists, and that takes judge time as well as facilities. And so the active retired judges, in my view, bring a store of knowledge and experience that is a huge benefit to the system, and I think will be a significant help in drawing down the backlog. And it's as I've said in my opening remarks, it's a huge benefit to the state for people like Judge Warren to be willing to do this.
Good, that's what I expected. Thank you.
Thank you, Representative Moriarty. Are there additional questions from committee members for Mr. Hobson? Seeing none, thank you very much again for the statement on the nomination. We appreciate your participation. At this point, the chair now recognizes the Honorable Thomas D. Warren for the purpose of making a statement concerning this nomination. Welcome to the Judiciary Committee. Justice Warren, please proceed when you feel comfortable.
Thank you, Representative Harnett, Senator Carney, and members of the Judiciary Committee. I'm Tom Warren. I am pleased to be here today, and I'm honored to have been nominated for appointment as an active retired justice of the Superior Court. And I want to thank Jerry Reed and John Hobson for their kind words, and for Governor Mills to have decided I was worthy of that nomination. It is my great privilege to have served on the Superior Court since September of 1998. And in that time, I've presided over Superior Court cases in almost every county of Maine, from Aroostook down to York and from Washington to Oxford. Most of my travels as a judge occurred early in my career, and most recently I've been assigned primarily as a justice in Portland as part of the single judge assignment system for civil cases in Cumberland County, and as one of the judges assigned to the Unified Criminal Docket in Cumberland County. I live in Portland with my wife, Carol Warren, who is a retired lawyer. Actually, I guess I should say an almost fully retired lawyer, because she's been winding down her practice for the last 2 years, and I think she's almost fully succeeded in doing that. We lived in Brunswick until 2015, and our son Andrew was raised in Brunswick and went through the Brunswick school system. And then since then, he's went to college down in Boston, and he's remained in the Boston area. Before I became a judge, as I think you heard, I practiced law for 23 years, first briefly with a law firm when I was actually earning enough money so that my wife could go to law school. Then after that, pretty much continuously in public service, first for 6 years as an assistant U.S. attorney in the Southern District of New York, doing civil litigation and then later civil and appeals. Then for around 14 years in the Maine Attorney General's office. For 10 of those, I was chief of the Civil Litigation Division, and I had the opportunity to do both trial and appellate work in both state and federal court, a lot of federal court work. And in one case, I got the opportunity to argue in the United States Supreme Court defending the constitutionality of a Maine statute. Since 1998 as a Superior Court Justice, I've been presiding, and I think I estimated that I've had approximately 400 trials in that time, including jury trials on criminal charges ranging from criminal speeding to homicide, and both jury and non-jury trials on civil cases ranging from personal injury to commercial litigation to boundary line disputes to judicial review of decisions by state agencies and by local municipalities. And I probably also issued a lot of decisions or played some role in numerous, maybe vast number of criminal and civil cases that were resolved without trial. Most recently, during the pandemic, I was the chair of something called the Jury Management Group, and we were tasked with the unenviable assignment of trying to figure out how to conduct jury trials during the pandemic. And we devised various procedures, which have since, in some respects, been modified, but which have been trying to make sure that we could still proceed, because basically the criminal justice system can't shut down forever because of the pandemic. And we've been delayed greatly, but we're trying to get at that backlog, I think, as has been stated. I'm seeking appointment as an active retired justice because although I think it's time for me to ratchet back, I would like to continue to serve the justice system and the citizens of Maine. In particular, as I think Representative Moriarty's question underlined, we're struggling with the backlog and the pandemic. And in Cumberland County right now, I think there are fewer Superior Court justices available than there were before the pandemic. And the district court judges have been extremely busy with their priority dockets, and they haven't been able to participate as much in the unified criminal docket. So I want to help at least until the court is at full strength, and until, if possible, we can start eating into the backlog, and then to be called in as needed. They get to decide. I don't what I do from there. But for specific cases of dockets, there's been some talk of having active retired judges try to work with the civil, with the backlog of civil cases, which are lower priority than the, unfortunately, lower priority than the criminal cases where you've got people who are facing the loss of their freedom. In particular, I hope to keep participating in something called the mental health docket in Cumberland County, which was originally set up by now retired Justice Mills. It's designed to identify and monitor the status of criminal defendants who have mental health issues. And it's one of the more worthwhile and challenging aspects of the criminal justice system because, as I'm sure all of you are aware, the criminal justice system has become, I guess I call it the catchment basin for many persons with mental health issues whose needs are not being addressed. So the only other thing I guess I should say really is just to reach out just to say about all the people who've been working during the pandemic under what I would describe as incredibly grueling and frustrating conditions whose service should be recognized. That's not just the other dedicated members of the judiciary, my colleagues, who are committed, I believe, to fairness and protection of constitutional rights and upholding the rule of law, but the clerks and the court staff who are essential to the operation of the justice system and who work very hard every day to make that happen and have been doing so throughout the pandemic, albeit occasionally with notices that someone is being forced to quarantine because of some kind of exposure. I need to thank and commend the lawyers who are fundamental to the adversary system for their dedication and their diligence in representing their clients, and have been doing so under very adverse conditions during the pandemic. And finally, the jurors, who many are coming in, doing jury service, describing it as worthwhile. We've been asking them, you know, are they comfortable during the pandemic? Are they comfortable with the COVID precautions that are in effect? And they're willing to perform their civic duty and they're essential to the operation of the criminal justice system and to the confidence that people have in it. So they all need to be recognized here. And lastly, I guess I'd say that being a trial judge is an extraordinarily interesting and challenging job, and it's an enormous responsibility that I have attempted to live up to and that I will continue to attempt to live up to if I am confirmed as an active retired justice. So with that, I'm happy to take any questions from any members of the committee.
Thank you very much, Justice Warren, and thank you for a long career of public service. Are there questions from committee members for the nominee? If so, if you could please raise your electronic hand and keep it up. I will start with Representative Thorne, followed by Representative Evangelos. Representative Thorne.
Thank you, Justice Warren. Thank you, Chair. Mr. Justice, if you could help me understand what the those of us that aren't in law and don't go to court, in a nutshell, can you describe what prevents this type of Zoom or video conference from clearing up a lot of cases that don't require trial?
I think for cases that don't require trial, I think we are now, the judicial branch is now trying to do as many of these cases as possible on Zoom. It's not always as easy as it sometimes seems, because I've had more Zoom conferences than I'd like to count, where someone can't get on, where they suddenly freeze, where they are on a cell phone in their car because it's the only private place they can be, where they lose battery and or can't connect in for whatever reason, because it's hard to give notice to people to say, here's how you get on. And not everybody's able to do that. For non-trial work, we're trying to go to as much of this as possible. I should say that some lawyers request in person for certain events, such as sentencings, where it's a disputed sentence, because they don't think it really is as meaningful to have people as sort of disembodied faces on a screen, but we're trying to do that. Then the trials themselves, where there have been attempts, and probably will be more attempts, to try and do at least civil trials on Zoom. But that's hard, because if you want to show a document to a witness, it isn't always easy to do that. And then it's awkward. For criminal trials, defendant has a right to confront the witnesses against them. I have not seen, with one exception, I have not seen any criminal defendant who's willing to waive that right. So we have to have a trial in person in almost all cases with a jury, unless someone's willing to waive the jury. And that's what makes it go slow. And part of the problem in Cumberland right now is we're so backlogged with criminal matters, we can't even get to the civil matters in any meaningful way in terms of trials. We can rule on motions, we can have other kinds of hearings, but we haven't had the time to do many trials.
All right. Thank you for that, Justice Warren. Thank you, Mr. Chair.
Thank you, Representative Thorne. Representative Angelos.
Thank you, Mr. Chair, and good afternoon, Justice Warren.
Good afternoon.
Justice Warren, I have a series of questions regarding your sentencing philosophy and what you determine is your discretion while you're sentencing, and what guidelines you feel you have to follow, because quite frankly, I'm deeply troubled about how you handled a couple of cases, and I'll elaborate in questioning, but I wanted to give you a chance to talk about discretion in your philosophy.
Did you just want me to tell you where I start and what I'm trying to do, or do you want to talk about something in specific?
Well, if it would help get you focused, we can move on to the specifics. But
no, I'm happy to. Well, I mean, there is both the law court and the legislature have set forth the general sentencing principles. They're in the statute. I think it's now in section 1501 of Title 17A, and then there's a procedure where we are required to consider the nature and seriousness of the offense. Then we're required to consider what mitigating and aggravating circumstances there are. And then we are except in homicide cases, we decide whether or not to suspend or not. And I think that the sentencing is the hardest thing I think we do. It's something that makes people, I mean, there are a lot of people who are unhappy with various sentences. I know that in the past, I've had victims' families unhappy. I've had prosecutors unhappy. I've had defendants unhappy. I've had defendants' families unhappy. And you're just trying to set a sentence that fairly holds people accountable, that takes into account their prospects for rehabilitation, that takes into account their specific circumstances, but that is not dissimilar from sentences given to other people in the same position, to the extent you can discern that cases are in fact similar.
thank you for that. Let me overlay a couple of cases that have me so concerned. In 2020, Tyrese Collins, who was originally charged with murder, and then a plea deal was arranged for manslaughter. He killed somebody. His victim died from a gunshot wound. There was an element of self-defense in it. But in your statements, you saw great hope for rehabilitation in him. And despite the fact that another man died and the victims' families were very unhappy with the negotiated outcome, Tyrese Collins got 6.5 to 10 years, 3.5 suspended. He got 6.5 years in prison for killing somebody. In 2010, in the Brandon Brown case, And by the way, in both of these cases, one is 20 years old, the other is 23. They both accepted responsibility and threw themselves at the mercy of the court. Mr. Brown was in a confrontation in Portland. He shot somebody. He had been, according to the record, there was an altercation and a fight. There was an element of self-defense, but he was found guilty. And despite his possibility of redemption and improving himself, his victim didn't die. And you gave him 27 years in prison, 17 to 27, 10 suspended. And I don't understand how when somebody kills somebody, they get 1/3 the sentence of somebody who didn't kill somebody. What can you tell me as to how you arrived at those outcomes?
Well, all right. First of all, on Tyrese Collins, I don't remember too much, but if I'm right, it was a plea deal that was reached by the state and the defense. Actually, it may have been the state and Mr. Collins. I'm not sure his attorneys, what their position was. In the middle of a trial, am I right about that with Mr. Collins? And I think that was where everybody agreed after they heard some testimony that I think surprised the state, that there was a much greater element of self-defense. They didn't want to let it go all the way to a verdict because Mr. Collins didn't want to run the risk of a murder sentence. He was charged with murder. And the state thought that there was enough of a chance of self-defense that they wanted to offer something a lot less. And I went along. I don't recall whether I said anything about Mr. Collins's chance for rehabilitation, but my understanding was that that was a sentence that was agreed to in the middle of a trial, if I'm remembering that correctly. On Brandon Brown, first, that went to trial. That was not a sentence where Mr. Brown put himself at the mercy of the court. Mr. Brown was someone, I actually remember that case fairly well. He was someone who had gotten in an altercation with the gentleman he later shot, who was a person who was had served several tours of duty in Iraq or Afghanistan, and had thrown Mr. Brown out of a strip club, and Mr. Brown felt disrespected, and he said several times he wanted to shoot the person whose name was Sanders, I think, the person who was the victim. And then there was an instance where, if I'm remembering this right, Mr. Brown saw Sanders on the street in the Old Port. He went upstairs. He got his gun, he loaded his gun, he came back down. And then it was one of those nights in the Old Port where scuffles were breaking out. One broke out here. Mr. Brown and Mr. Sanders somehow were involved, at the end of which Mr. Sanders is rising to his feet. Mr. Brown stepped back, aimed the laser sight right into Mr. Sanders' chest and pulled the trigger. And he nicked some inner organs and put and the spinal cord was severed or at least damaged, and Mr. Sanders was in a wheelchair and would be, as I understood it, for the rest of his life. So that was a elevated aggravated assault. It was a attempted murder. The jury found him guilty of both those things, even though he had argued that there was self-defense because he said that Sanders was reaching for a knife. But the state offered evidence that their knife was not present until after the shooting, when a friend of Mr. Brown's had dropped it on the street. And so you have a trial where there was not a situation of acceptance of responsibility. And Mr. Brown was alleging self-defense, and the jury disregarded and didn't believe that story. and you'd reduced Mr. Sanders to a wheelchair for life. And it seemed to me an attempted murder plus a very high degree of victim impact, plus an elevated aggravated assault added up to a 27-year sentence, all of which I suspended all but 17. And I think in doing that, I may be doing the math wrong, but I knew that Mr. Brown would get good time and he'd be out in 12 or 13 years, which I thought was a fair sentence under the statutes, suggesting that I shouldn't diminish the gravity of the offense. But he was a young man, and after 13 years, he would be able to go on and hopefully be rehabilitated. And I understand he has been rehabilitated and is doing quite well. So that's the reason, the differences as I see them. And
let me refresh your memory. The Tyrese Collins case was just January of 2020, and I'm quoting you now. The seriousness of this crime, the fact that it was so unnecessary, and the amount of suffering, weigh that against Mr. Collins' right to have a chance at rehabilitation, his potential for rehabilitation, and the fact that he is starting with having the cards stacked against him that he can hopefully overcome. I think that 6.5 years should be suspended, Warren said. So, I find it a little ironic that you have a very sharp memory in the Brown case, but a case that's just 2 years old, you're struggling.
I am, and maybe I misstated what happened in the Collins case. As I said, I thought it was a case where where a plea was reached during the middle of trial.
Okay. And in the Brown case, in a quiet, packed courtroom Monday afternoon in 2010, Brandon Brown stood and accepted responsibility for shooting another man outside of Portland, a nightclub. Now, one of the things I'm troubled about is, do you think there should be a penalty in sentencing for pleading innocent? Don't we have a constitutional right to a fair trial and not to suffer retribution for exercising our constitutional rights?
Absolutely no penalty for going to trial. I absolutely agree with that.
Well, somehow he ended up with a sentence 300% higher than a man who was being charged with murder and then downgraded. I don't think that is a fair or just outcome. I want to raise some other issues.
Well, let me just say, Representative Evangelos, I respect your opinion, but I see. All I can tell you about acceptance of responsibility is it is a mitigating factor, but failing to plead and deciding to go to trial can never be an aggravating factor.
Well, it wasn't his sentence.
No, it wasn't.
Okay. I want to move on to a subject. It's from an abstract I have from the Oklahoma Law Review, and it's called Combating Prosecutorial Misconduct in Closing Arguments. And I'll just read you the introduction. Prosecutorial misconduct in closing arguments is rampant. Prosecutors make improper arguments because it is highly effective, yet virtually risk-free. That is, even if the defense lawyer quickly identifies and objects to the misconduct, the jury has already heard the improper argument and the available remedies are toothless. Now, in the Gideon precedent in 1963, which led to poor people obtaining the right to defense counsel, it's pretty implicit in that many poor people are dressed and disheveled. And the way you're dressed or the way you appear has absolutely no bearing on somebody's guilt or innocence. Yet the prosecutor in Brown's case, Meg Elam, made references to the way Brown was dressed in her closing arguments to suggest that he's some kind of a gangster or something. That is inappropriate. And I want to know why you didn't stop her.
Well, first of all, Representative Evangelos, I don't really remember that. I don't know that there was any objection from defense counsel, but my recollection was that the issue of clothing, and I actually remember that case better than probably many, but I'm not sure about this, but my recollection is that the way that came up was that Mr. Brown, the reason he was upset about and felt disrespected for having been thrown out of the strip club was his pants fell down during that process. And I think that's what was being referred to. That's the only way I can even possibly connect that up. Certainly, Mr. Brown was not dressed in the courtroom in any way that could have resulted in any kind of comment.
No, but for a prosecutor to make allusions about the way a criminal defendant was dressed is totally irrelevant to the facts of a case. And the codes of judicial conduct would have required you to stop her and say, "Wait a minute, we don't talk about that. That's prejudicial to the jury." That was inappropriate. I think it was the subject of one of his appeals, so I'm surprised you don't remember it. My final line of inquiry on this is that on February 9th, 2021, we held a confirmation hearing with a very fine district court judge nominee, and I overlaid these two cases to her. And I asked her, how could it be possible for somebody to shoot and kill somebody and they get 6.5 years? And in this other case, the Brown case, he gets 17 to 27. I mean, clearly Brown had as much possibility for redemption as Collins. I want you to know, I received a letter from James Sanders. I've been meaning to write this letter for a while to say, I hope your growth continues and that I let go of anger and pain. Forgiveness and bettering ourselves is the way to be. So with that said, I hope this letter leads to an early release. I don't think your characterizations of Mr. Sanders' wounds and his long-term injuries are accurate. I've spoken to him on the phone twice. But in this particular confirmation hearing, I asked this judicial nominee, how could it be possible? And her answer on the record was, Representative Evangelos, all I can say is it was the result of human error. And, I can accept with all the work you've done and all the cases you had that, we're not going to get it perfect all the time. But it's important for me to hear from you that you may have made a mistake in that sentencing.
Well, let me say two things. The first is it's a great credit to Mr. Sanders that he's moved on and what you're quoting. That was not his attitude at the time of trial. He gave a very striking victim impact statement. I think it was written explaining how this wound had affected his ability to engage in the most basic bodily functions at that time. Let me also say that on sentencing, it's tough. If you think that's a mistake, I respect your opinion on that. And it's entirely possible it is a mistake. But I don't think the comparison to a negotiated plea under circumstances that I clearly don't remember what the story was in the Tyrese Collins case, and a case where someone shoots somebody and leaves them in a wheelchair for life and alleges self-defense when the jury found that it wasn't, is exactly comparable. So I have to say that while I may have made a mistake, and I'm willing to acknowledge that I make more than one mistake, and that may be one of them, I don't find the two to be comparable, and I'm sorry, and I respect your opinion to the contrary, sir.
Well, and the facts are, sir, that Mr. Collins' victim is dead and Mr. Sanders is alive.
True.
That's all I have, Tom.
Thank you, Representative Evangelos. Thank you, Justice Warren. Are there additional questions from committee members? I'm checking the panelist list and not Senator Carney.
Thank you, Co-Chair Harnett, and Justice Warren, thank you for being here today. You had mentioned that you hope to continue to be involved in the mental health docket in Cumberland County. And I'm not sure that we as a committee had heard about the mental health docket. So I had a couple of questions. One is that restricted to just Cumberland County? And then could you explain to us why you are particularly interested in continuing to be involved in that docket?
It's not restricted just to Cumberland County. It started in Cumberland County because, and it was started by Justice Mills, because Cumberland County has the greatest population of cases involving mental health issues. And the theory of the docket was to avoid having people with mental health issues sit on in the docket and sort of wait until their case otherwise got resolved, because basically those cases don't get better with time. And her idea was to try, and I think it was brought to her attention by some defense lawyers, that people were sort of sitting around waiting for their cases, some of them in custody, some not. And they really weren't in no shape. They were either not competent to stand trial, or they had serious mental health issues that somehow should be addressed. So she set up a docket which was designed every week to try and identify those cases early, to make sure they had lawyers who understood the issues in those kinds of cases, to get them competency hearings in those kinds of cases as soon as you could, at least evaluations, and then to try and divert them to the extent they could be diverted out of the criminal justice system into other treatment. And there isn't enough treatment. There are not enough beds at Riverview. There are not enough group homes. But there are people who work very hard. They're intensive case managers from DHHS. They're the ACT teams, which is an acronym that I'm not sure I can correctly. I think it's assertive community treatment teams. And there are people who work, there are people at the jail here who work hard at trying to identify people and say, look, this person is in really bad shape and we need to try and do something. And and then she retired, and it was a successful enough here that they've been starting it up in other counties, and they've replicated it in, I think, 4 or 5 other counties now. We were doing it once a week. I think in the other counties, it might be once a month, or maybe somewhere in that range. And there's not enough treatment. There are not enough group homes. And some of the people involved are extraordinarily resistant to treatment. They don't want to. They don't want to take psychotropic drugs. But the theory would be to at least monitor those cases, not let them get lost, stay on top of them, try to push them to a resolution with the prosecutors, who have generally been quite accommodating in saying, this is a very serious crime, but if we can get this person as some kind of treatment, we will, not pursue it much further, maybe time served or probation or nothing. And to get people who are literally incompetent to stand trial out of the system, because you have to dismiss the case when that's true, and to try and move them. And she retired, and I took it over. And the reason I like the docket is we're trying to help people. We're not successful by any means, but we're addressing a serious problem, which is that the criminal justice system and the jails have ended up as the the place where people with mental illness, some of them, a lot of them homeless, end up. And often they shouldn't. Now, we can't all prevent that, but we we try, and I try to urge people to dismiss cases when there's literally no point in proceeding. The prosecution has been at least willing to listen to me, and they agree sometimes. And so it is, I won't say rewarding because we're not successful enough, but it's a worthy effort. And that's why I'm interested in it. And I think Justice Mills would like to do more in a retired state, and so would I. And we've talked about how we both could be involved.
Thank you both for your answer to my question and also for your efforts in that regard.
Thank you, Senator Carney, for the question and for the response, Justice Warren. Are there additional questions from committee members? I am not seeing any, so I will now move on. Thank you very much for your statement, Justice Warren, and for your response to the committee's questions. The chair will now take comments from persons attending this hearing who wish to speak for or against the nomination. Anyone who has a written statement but who does not wish to speak should have submitted that statement with the committee clerk prior to today's hearing. All such statements shall contain the name and residence of the person who prepared the statement. A copy of each written statement presented to the committee at this hearing will be made available to the nominee prior to the committee's vote, and the nominee will have an opportunity to respond to the written comment. Those who wish to speak in person registered with the committee clerk prior to the start of this hearing and will be called upon by the chair, at which time they will be promoted to panelist status in Zoom, and they will be seen and heard. When it is your turn to speak, please observe the following. State your name and place of residence prior to presenting your testimony. Only comments concerning the suitability of this particular nominee for this particular position will be considered in order. All other comments will be considered out of order. After you are done speaking and there are no more questions from the members of the committee, you will be returned to attendee status and the next person will be called. I will now ask if there are any persons who are here as attendees who wish to be heard on this nomination. If so, please raise your electronic hand so that the committee clerk can move you over to become a panelist. And I am not seeing anyone in the panelist room who wishes to speak on this nomination. So I will proceed. I will just check one more time to make sure I have not missed anyone. And again, not seeing anyone. Excuse me. I will now proceed with a concluding statement by the chair. All public comments having been taken, the committee will now proceed as follows. We will review any additional written comments on the nomination that have been received by the committee. We will vote on the nomination and notify the President of the Senate pursuant to Title III, MRSA Section 157, and the joint rules. The vote must be taken within 40 days from the date of the governor's written notice, and we are within that time frame. The hearing by the Joint Standing Committee on Judiciary for the Honorable Thomas D. Warren of Portland for appointment as an active retired justice of the Superior Court is now closed. We will proceed to taking the vote. In accordance with the law, the committee may not take the vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all committee members who are present agree. At this time, therefore, I will ask whether any member present objects to proceeding to take the vote immediately. If so, please raise your electronic hand. I know that earlier today, there was some concern about not having received information and committee members wanted to review that. I am not sure that this applies to this nominee, but I will again ask if there is any person who objects to proceeding directly to a vote. And and I am not seeing one. Therefore, the pending question before the committee is that the Joint Standing Committee on Judiciary recommend to the Senate of the 130th Maine Legislature that the nomination of the Honorable Thomas D. Warren of Portland for appointment as an active retired justice of the Superior Court be confirmed. In accordance with Title III MRSA Chapter 6, Section 157, and with the joint rules of the 130th Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of recommending confirmation. A vote of no will be against the motion to recommend confirmation. Is the committee ready for the question? Seeing no objection, I would ask the committee clerk to please call the roll.
Thank you, Mr. Chair. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Representative Evangelos.
No.
Representative Evangelos votes no. Representative Poirier.
Yes.
Representative Poirier votes yes. Senator Keim. Senator Sanborn. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Sheehan. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby. I'll recall the absentees. Senator Keim. Senator Keim is absent. Senator Sanborn. Senator Sanborn is absent. Representative Sheehan. Representative Sheehan is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Mr. Chair, I'm seeing Senator Keim coming back on. Should we wait?
You could ask her if she's ready to cast her vote now or at a later date.
Senator Keim?
Are you prepared to cast a vote on this nominee?
Sorry, I will cast my vote later. Thank you.
Thank you. And Representative Sheehan? I'm
I
sorry.
apologize. For confirmations, there are no absentee votes, Senator Keim. I need to have your vote on camera or I will have to mark you as absent. I'm sorry.
I'm fine with absent. Thank you.
Okay. Representative Sheehan?
Yes.
Representative Sheehan votes yes.
I just want to make sure I have my numbers right. Thank you, Committee Clerk Panett. Am I correct that there are 9 votes yes, 1 no, and 4 absent?
Mr. Chair, not wanting to do a wrench in this, we have a person on screen. I don't know if I can mark her as absent, and I do apologize. That's your call.
Well, she's indicated she's unable to vote, so I will note that as absent on vote. So we can
Absent or abstain?
Is abstain a possibility? I must confess, I do not know.
Could we simply have Senator Keim leave and just rejoin us for the next confirmation hearing that's going to start in a moment?
Thank you very much.
So we have 9 members of the committee having voted in the affirmative and 1 in the negative. It is the vote of the Joint Standing Committee on Judiciary that the nomination of the Honorable Thomas D. Warren of Portland for appointment as an active retired justice of the Superior Court be confirmed. Justice Warren, congratulations. Were these more normal times, we would be leaving our seats in the horseshoe to come down and congratulate you in person. And I would be pointing out that because I am so much younger than you, although you did not mention it, I interned with you in my second year of law school when you're at the United States Attorney's Office for the Southern District. So we go back quite a bit. But I want to congratulate you, and our new tradition on judiciary is to give you a virtual round of support, of applause, with our appreciation for your continued public service.
Thank you. Thank you.
Thank you very much. And that concludes the confirmation hearing regarding Superior Court Justice Warren. I'm going to just take 2 minutes to gather my papers for our next confirmation. I'm not going to go anywhere, so if you guys could hang around, that would be great. Thank you. The Judiciary Committee will now take up the nomination of the Honorable Susan Orem for retired status as a district court justice. I want to make sure that the nominee is with us before commencing the hearing.
She is not, Mr. Chair, nor is she in the attendee space.
I am seeing that as the case, nor is.
There she comes.
Here she comes. Thank you. Welcome back to the Judiciary Committee. This is a public hearing of the Joint Standing Committee on Judiciary for the purpose of considering the nomination by the governor of the Honorable Susan Orem of Falmouth as an active retired judge of the district court. Under the law and joint rules of the legislature, this committee is required to hold this public hearing and to recommend confirmation or denial of the nominee by majority vote of the committee members present and voting. As the chairs of this committee, Senator Carney and I will then send written notice of the committee's recommendation to the President of the Senate. The committee will hear testimony from and have an opportunity to question the governor or her representative, the nominee, and any other persons present who wish to speak for or against the nomination. Today's meeting is currently being live streamed on the committee's YouTube channel. This means that anyone who is a participant in the meeting via Zoom can be seen and also heard if their microphone is unmuted. People testifying cannot be seen or heard until they are called upon to speak. This meeting will be recorded and available to view on the committee's YouTube channel shortly after today's proceedings are concluded. Pursuant to Title III, Section 157 of the Maine statutes, which requires that there be an affirmative motion to recommend confirmation of the nominee, the chair recognizes Representative Moriarty for the purpose of making such a motion. Representative Moriarty.
Thank you, Mr. Chair. I move that the Joint Standing Committee on Judiciary recommend confirmation of the Honorable Susan Orem of Falmouth for appointment as an active retired judge of the district court.
Thank you, Representative Moriarty. Do I have a second? Seconded by Representative Babbage. Thank you. A copy of the statutory requirements for this position is available and accessible to the public online. The chair now recognizes Jerry Reed, counsel for Governor Janet T. Mills, for the purpose of making a statement concerning this nomination. Mr. Reed.
Thank you. Good afternoon, Representative Harnett, Senator Carney, members of the Judiciary Committee. My name is Jerry Reed. I'm counsel to Governor Mills, and it's my pleasure to be here this afternoon to present the Honorable Susan E. Orem as the governor's nominee for appointment as an active retired judge of the Maine District Court, from which she retired as an active judge on December 31st of last year. Judge Oram was appointed to the District Court in 2010 and reappointed in 2017, at which time she was serving as the Chief Judge of the District Court. Prior to joining the bench, Judge Oram was a family law magistrate in the District Court, a position she held for 7 years. Before that, she had a varied legal career, which included both the private practice of law, working for several years as an adjunct college instructor in legal and paralegal studies. Judge Oram graduated cum laude from Colby College with distinction as a philosophy major and earned her law degree from Vermont Law School. While serving as Chief Judge, Judge Oram had the opportunity to sit in district courts throughout the state, from York to Aroostook counties, and was also part of the team implementing the electronic case management system. In recent years, she has sat primarily in courts in Androscoggin, Oxford, and Franklin counties, and has spent significant time presiding over the Family Recovery Court in Lewiston, which is designed to support parents in child protective proceedings who are in recovery from a substance abuse disorder. Judge Oram has been one of the district court's stalwart judges, and her retirement from active status is a significant loss for the judicial branch. She is a knowledgeable, efficient, and compassionate judge who skillfully meets the challenges presented by pro se litigants. Her appointment as an active retired judge of the district court is well deserved, and the people of the state of Maine will be fortunate to have her continued service in this capacity. On behalf of the governor, I respectfully request your support for the nomination of the Honorable Susan E. Oram as an active retired judge of the Maine District Court, and would be pleased to answer any questions you may have of me. Thank you.
Thank you, Mr. Reed, and for bringing this nomination forward for the governor. Are there questions from committee members for the governor's counsel, Mr. Reed? If there are, if you could please raise your electronic hand. And I am not seeing any, and I should have mentioned that we have multiple representatives of the governor's office here today, and I would now turn to John Hobson of the Judicial Selection Committee. Welcome to the judiciary, sir, and please proceed when you're comfortable.
Thank you very much. Representative Hartnett, Senator Carney, members of the Joint Standing Committee on the Judiciary. My name is John Hobson. I am Chair of Governor Mills' Judicial Selection Committee. And on behalf of the Selection Committee, I request that you act favorably on the nomination of Judge Susan Oram, now retired Judge Susan Oram, as an active retired judge to the Maine system. As I've mentioned in comments to other judges who have sought active retired status, the active retired judges are the great benefit to the state. They are perhaps the biggest budget bargain, actually. Their wealth of experience and their ability to chip in where needed is really crucial to keeping the judicial branch going. There's one aspect of this particular nominee, Judge Oram, that I can tell you from personal experience, really illustrates why the Maine judicial branch works as well as it does. Judge Oram has been, as Mr. Reed said, a stalwart of the system. She is somebody who has done her job, has done an excellent job, but does it without fanfare, without flash, and was always willing to go up to the far reaches of the county, to over to Washington County if needed to chip in because there was a judge that needed to have filled in, was just always willing to do what needed to be done to be able to serve the needs of the Maine people. And we are tremendously lucky that she is again willing to extend the state service past the retirement date as an active retired judge. As I said, she exemplifies what it means to be a really good, hardworking judge with excellent organizational skills, excellent judgment, and a real care for the Maine people. So on behalf of the Judicial Selection Committee, I ask that this committee act favorably on the nomination of Judge Oram. And of course, I'm happy to answer any questions the committee may have.
Thank you very much, Mr. Hobson, for your statement. And I will now turn to the committee to see if there are any questions for Mr. Hobson. If so, please raise your electronic hand. I will begin with Representative Babich and then proceed to Representative Moriarty. Representative Babich.
Thank you very much, Mr. Chairman. Hello, Mr. Hobson, and I want to thank you for your work on this committee over the years. I appreciate all of that effort and the importance of what the committee does. I did ask Mr. Reed this morning about the process as far as the recruitment of supporting testimony from attorneys. And I thought it's only fair that I ask you if that's something you do or if the committee does that in a formal way.
I'm not sure I could say the committee does it in a formal way, but I have certainly worked with nominees to have them be able to get supporting testimony. It's typically not sitting judges that I work with. I have worked with nominees for other positions and suggested to them that they have people who come out support them, try to get them to identify who would come out there. I don't think that I've ever actually contacted anybody myself. I usually have the nominee do that, but I try to have the nominee make sure they understand that it's helpful to have people supporting them in front of this committee to give them a sense of what their peers and others think of them. And so I have encouraged in the past that nominees have support. Supporters should come, and I leave it to them to identify who they are and have them get them agree to do it. But absolutely, I have encouraged that in the past, and the trial lawyers and the obviously come on their own, but that's really different, I think, than having someone who knows the nominee personally. I think it's probably helpful for this committee to hear that. We as a committee, I will tell you, find it helpful in evaluating nominees to speak with people who have practiced with them or know them in terms of their qualifications of whether they should be presented to the governor as a recommendation for the committee. So I feel that it's helpful for the nominee to bring people before this committee who can basically give the same kind of testimony as to the character and of the person involved.
Well, thank you for that. And please understand that at least in my case, when I see testimony from a person that I know and admire and respect, then that does carry weight, especially if they have a perspective that I'm unaware of. I do want to bring to light the fact that, any defense attorney or prosecutor, for that matter, that may soon appear before this person is unlikely to want to alienate them in any way. And I would wonder if refusal to testify would in itself be a message that would be unwelcome. So I'm just sort of examining the process out loud with you here.
Well, just so you know, and without going into too much detail, before the person ever gets to the stage of being recommended to the governor, the committee has done a background on that person and talk to their peers, and we've tried to get the input. So we feel we have a pretty good idea about the standing of the particular person involved.
Thank you for that. Thank you, Mr. Chairman.
I'm usually the one telling people they're muted. Thank you, Representative Babich and Mr. Hobson, for your response. Representative Moriarty.
Thank you, Mr. Chair. Mr. Hobson, I just have a quick clarification to request.
Sure.
It appears that Judge Oram is currently midway through her second full term as an active judge. My question is whether she has in fact retired or whether she would do so if the present nomination to active retired status is approved.
My understanding was that she had retired as of the 31st of December, but if I'm wrong on that, then I'll stand corrected.
I see Mr. Reed nodding on screen, so I guess you got it right. Thank you. Thank you.
Thank you, Representative Moriarty. And the retirement date is in the statement submitted by Mr. Reed on behalf of the governor. Are there additional questions from committee members for Mr. Hobson? Seeing none, again, thank you very much for your time today, sir, and for your participation in this process. And you have one more to go. We'll see you in a bit. I now welcome, the chair now recognizes the Honorable Susan Oram for the purpose of making a statement concerning this nomination. Judge Oram, welcome to the Judiciary Committee. Thank you for your public service, and please proceed when you're comfortable.
Thank you, Representative Harnett, Senator Carney, honorable members of the committee. I am Susan Oram, and I very much appreciate the opportunity to appear before you today to talk about the governor's nomination of me to serve as an active retired judge in the district court. I'm very grateful to her for nominating me. I appreciate very much the kind remarks made by her counsel, Attorney Reed, and by Attorney Hobson as well. And I welcome the opportunity to appear before you as you discharge your important constitutional obligation to the folks in Maine as you consider these nominations. You have had a very busy day and you've got more to go, so I will try to be brief in my remarks. I want to tell you just a little bit about me and why I think this work is so important, and a little bit about why I hope you'll give me an opportunity to continue it. I was not born in Maine, but had the good fortune to attend Colby College in Waterville. And at that point in my life, I fell in love with Maine. After college, I was away from the state of Maine for about 10 years, living and working, but I came back to Maine as soon as I could. Until about 6 months ago, Auburn had been my home, and it was a wonderful place to live and to work and to raise a family. My children now are all grown and spread across the country. One of my daughters is a director of digital product for a Boston-based company. My son is a pilot in the Air Force and lives in Oklahoma with his family. And my other daughter is in Vermont working on watershed and habitat protection and restoration projects. I am tremendously proud of them and their families. And I will tell you that the reason I've asked the governor to consider this for me and that I retired is not because I am tired of this work or burnt out or worn down in any way. I love this job, but I wanted an opportunity to spend a little bit more time with my family with a little more flexibility than this job typically allows us to have. So it's our job, yours and mine, each in our own way, to serve the public. We are called to be public servants and to serve the public in a way that strengthens their faith in our rare and precious and unique form of government. I think about this responsibility every single time I go to work because government touches people powerfully in a courtroom. It is where the policies enacted by the legislature intersect with and are applied to individual lives. During my time on the bench, I have tried to make sure that every person appearing in front of me in every case leaves the court feeling that they have been fairly, compassionately, and patiently heard, and their dispute decided in accordance with the law, mostly as you have given it to us, because a good deal of the work in the district court is statutory in nature. I'm sure I haven't gotten this right every day, but I hope I have largely succeeded in living up to this standard. You heard I started it with the judicial branch in 2003 as one of the family law magistrates, and my good fortune to serve as a district court judge since 2010. During that time, I've done a whole variety of things, everything a district court judge plus usually does. Plus, I've had the opportunity to serve as the presiding judge on a family recovery court in Lewiston for just about 7 years, ending at the time of my retirement. If I have had any success in serving the public well during my time in the judicial branch, I want you to understand that it is due in no small measure to the other folks that I work with every day who care deeply about our system of justice. I have worked in almost every district courthouse in the state of Maine. I'm missing Calais and Madawaska, but I have worked in every other courthouse in the district courthouse in the state of Maine, from York to Fort Kent, most of them more than once. And in every single place I go, I can tell you that the clerks, the marshals, my colleagues on the bench, and the lawyers who represent the parties in the cases are working very hard every day to deliver justice to the people of Maine. During the last 2 years of this seemingly interminable pandemic, I have been especially proud of this dedicated group. The courts never shut down. The clerks, the marshals, the judges, and magistrates got up, got dressed, came to work in our courthouses every single day. And we have tried our best to keep the wheels on the bus and the trains on schedule during this pretty challenging time. In addition to the judicial branch personnel, I have been so very proud of and grateful for the members of the Maine Bar. Even before the pandemic, I knew we had among the most hardworking, dedicated, and generous bars in the country. If you look at the folks who give their time pro bono and all those other things that lawyers do, I've always been incredibly proud of and grateful for those folks. But during the last 2 years, those lawyers have continued to show up. They come to court, they meet with their clients, they help people through some of the hardest days of their lives, and we could not do our work without them. So I'm so very grateful for their work. It has been a real privilege to serve the people of Maine in the judicial branch, to hear their stories, and to get a chance to try to resolve their disputes. It would be a real honor to continue this work as an active retired judge, and I ask for your support for my nomination. That's all I really needed to say to you. I would be happy to answer any questions the committee might have for me.
Thank you, Judge Oram. Thank you for your public service. And if you are confirmed today, let's make sure we get you up to Calais and Madawaska so you can complete your punch card. Are there questions from committee members for Judge Oram? If so, if you could please raise your electronic hand and I will call on you in the order that you appear, beginning with Representative Galgay-Reckett. Representative.
First I have to, yes, I'm fine. Hello, Judge Oram. I first have to apologize for the occasional background noise. My cat does not like being indoors, and it's too cold out, so he is complaining periodically.
It is the world of Zoom, I think.
It is the world of Zoom, yeah. Anyway, I wanted to talk to you about something on your letter, and you've mentioned it in your testimony. I confess to being totally ignorant of the existence of the Family Recovery Court in Lewiston. And when I read the brief paragraph that you wrote about it, I became really excited because in my work over the years in the domestic violence system, it's absolutely, and in the child protective system to some extent, it's really clear to me that the nexus of catastrophes that you have been dealing with in that court between child protective and substance abuse are some of the most critical ways that we could deal with helping families. So I wanted to ask you a couple questions. One is, how did you think it went overall? But also, do you see are there other places in the state where there are recovery courts, family recovery courts? And if not, why not? And if there are, where are they? So.
All right. So I'm going to apologize to all of you. You would think after all these years on Zoom, I would learn not to look at the boxes and I would look at the camera instead. But I find that I look at the boxes, so I'm talking to the person, and Representative Galgay-Reckett is way off to my left. So I'm going to try to not to turn away from you all too much. So there are 3 family recovery courts in Maine. One is in Bangor, the other is in Augusta, and the third is in Lewiston. They are not limited to serving folks who are in those towns, but there is some physical participation required of court participants. So geography does limit them a little bit. So for example, in the Lewiston court, we have had folks who had cases in Oxford County, occasionally Franklin County, if we could work out the transportation pieces and so on. So there are 3. There could be more potentially. Some of that has to do with funding and resources. As you all know, probably better than I, the judicial branch doesn't have programs. We have people in buildings. So the way the judicial branch supports the family recovery courts is to make a judge available, usually for half a day, twice a month, to preside over first the team meeting and then to conduct the court session. There are other members on our Family Recovery Court team. They involve folks from the Department of Health and Human Services, folks who represent parents or who are guardians ad litem or both, people in the substance use treatment community, because that's not where I went to school and that's not what I'm expert on. So I could always use some help. Before each court session, we meet on the participants, see how they're doing, figure out what it is that we're going to try to do to assist them in the court session. And then the real focus on the team is the case management. Right now, Maine Pretrial provides the case management for all 3 of our treatment courts. And that's through a contract that goes out to bid through, I think it's DHHS. It might be behavioral services or both. And the person who could answer that question best for you, and I'm sorry I don't have it, is Richard Gordon at the Administrative Office of the Courts, who coordinates those specialty courts for us. And he could tell you more about where the funding comes from to pay the case managers and that sort of thing. Nationally, we don't have a lot of data in Maine for a number of different reasons, but nationally we know that courts follow best practices. We get to final outcomes quicker. Children reunify with their parents more regularly, and that parents return to child protective actions less often when they successfully complete a recovery court program. But I couldn't give you specific statistics from Maine.
Thank you, Representative Reckett, and thank you for your response, Judge Orman. Are there additional questions from committee members? I'm going to look for electronic hands. And I am not seeing anyone. If I missed anyone, if you could raise your real hand, just check for those. And I am not seeing any there as well. So we will now take statements from the floor. The chair will now take comments from persons attending this hearing who wish to speak for or against this nomination. Anyone who has a written statement but who does not wish to speak should have submitted that statement to the committee clerk before today's hearing. All such statements shall contain the name and residence of the person who prepared them. A copy of each written statement presented to the committee at this hearing will be made available to the nominee if requested prior to the committee's vote, and the nominee will have an opportunity to respond to the written comment if they desire. Those who wish to speak in person registered with the committee clerk prior to the start of this hearing and will be called upon by the chair, at which time they will be moved to panelist status in Zoom, and they will be seen and heard. When it is your turn to speak, please observe the following. State your name and place of residence before presenting your testimony. Only comments concerning the suitability of this particular nominee for this particular position will be considered in order. All other comments will be considered out of order. After you're done speaking and there are no more questions from the members of the committee, you will be returned to attendee status and the next person will be called upon. I know that we had one person who indicated they would be speaking in favor of the nominee, Erica Bristol. So I would ask Erica Bristol, if you do want to speak, if you could please raise your electronic hand so that you can be moved over to a panelist. And I would ask the committee clerk to move Ms. Bristol over, and also Mr. Frank Bishop, so he can testify after Ms. Bristol. Thank you. And I see that Erica Bristol has joined us as a panelist. Welcome to the Judiciary Committee. Please begin your statement as soon as you are comfortable. Thank you.
Thank you. Hello, members of the Judiciary Committee. My name is Erica Bristol. I'm an attorney practicing primarily family law out of Auburn, Maine. I am speaking in support of the nomination of Judge Orem as an active retired judge in the district court. I really can't say enough about how much I respect Judge Orem and how much I have looked up to her. I have learned so much from her just watching her on the bench over, I've been an attorney since 2007. Definitely over that time. I think Lewiston in particular is already missing Judge Orem as a full-time judge. It's a big hole, and we have already noticed, even though she's only retired at the end of December. I would point out to you that it's my belief that Judge Orem has been a role model for many attorneys, new attorneys, female attorneys coming into the system and learning how to do the work. That includes myself, and I know that that includes other attorneys as well. I just wanted to say a few points about Judge Orem in her role as judge and what that looks like in the courtroom. So above all else, she's faithful to the law and the fairness of the system. I think you heard that in her remarks to you today. It's 100% entirely true. She has so much empathy for litigants that come into the system, and in the district court, many, if not most of the litigants are in a difficult place in their lives, whether it be high emotions because they're going through a divorce, whether it be they're facing issues because of having a substance use disorder or untreated mental health issues, or they're involved with DHHS and their children are in foster care. Some of the most difficult issues I think that people face in our state, they happen every day, hour after hour in the district court. I am on the treatment team for the Family Recovery Court in Lewiston, and I have been throughout Judge Orem's time on that, working with that program. And so I got to see her preside week in and week out with the Family Recovery Court participants and see that empathy that she brings and that understanding. And I think one of the most difficult things to do is to walk a line between support and encouragement, but also accountability. And Judge Orem walks that line so well. She's really, I heard participants talk about how much they've missed her. And now that she's retired, we have a different judge running that program. But I did hear lots and lots of participants thank her for her work with the program and indicate that she's helped them so much. I would like you to know that Judge Orem stands out as a judge that's always listening closely. It's actually really remarkable. You can have a 5-day trial in front of Judge Orem, and at the end, she will summarize every litigant's position, evidence that she heard over 5 days. She can just on the spot summarize that into a paragraph, and it's remarkable. And it makes every single litigant feel heard, even if the decision doesn't go with what they're asking the court to do. No litigant walks out of a courtroom feeling like they weren't heard and that the judge didn't hear every piece of evidence and consider it. I think that even in a part-time active retired role, Judge Orem will provide so much benefit to the judicial system. As I heard discussed earlier, about the backup of cases, the backlog of cases. That's also true in Lewiston. There's a huge backlog of child protective hearings in Lewiston. It's my hope that Judge Orem would potentially be assigned to help us sort through all of those hearings that need to happen. And I would have total confidence that the outcomes would put the needs of the children in those cases first, and that all of those hearings would be done in a fair way. And I'm happy to take questions.
Thank you very much for your time today and presenting testimony to the committee. Are there questions from committee members for Erica Bristol? If so, please raise your electronic hand and I will recognize you. I am not seeing any, so again, thank you very much for taking time out of your day to present testimony to us. We greatly appreciate it. I would now call upon Frank Bishop to begin his testimony when you feel comfortable, sir.
Good afternoon, Senator Carney, Representative Harnett, and members of the Judiciary Committee. I just wanted to mention that we did submit a letter in support of the nomination of Thomas Warren to the Maine Superior Court as an active retired judge. I had to step out to take a call, so I must have missed the opportunity to speak. We are also testifying today. So I'm Frank Bishop. I'm here today as in my capacity as the president of the Maine State Bar Association. I'm an attorney that lives in South Portland and works out of an office in Portland, Maine. And on behalf of the Maine State Bar Association and its members, I am pleased to inform you that the association fully supports the nomination of Judge Susan E. Orem to the Maine District Court as an active retired judge. Is that a misprint? Is it the Maine District Court or is it the Superior Court?
It's the District Court.
It is the District Court. Okay, it's not a misprint. I've already been over our process. As you know, we solicit feedback via electronic surveys from all of the lawyers who practice in Maine. And then we review those responses and compile those in a summary that ends with us either supporting or not supporting a nomination. Our surveys for Judge Orem identified her as a compassionate, thoughtful, and fair jurist. She was described as intelligent, attentive, courteous yet firm, and patient. Attorneys believe Judge Orem takes her judicial responsibilities very seriously, resulting in well-reasoned and timely decisions. She is commended for her knowledge of substantive law, especially in family-related cases. And for these traits, have earned her the support and respect of our MSBA members. We think Maine citizens will benefit from Judge Orem's continued service on the Maine District Court as an active retired judge. So we urge the Judiciary Committee today to give its unanimous support to the nomination of Susan E. Orem to the Maine District Court as an active retired judge today. If anyone has any questions, I'm happy to address them now.
Thank you very much for taking time out of your day to present testimony to the Judiciary Committee on this nominee. Are there questions for Frank Bishop from any committee members? If so, please raise your electronic hand and I will go through the list. I see Representative Thorne. Representative Thorne, go ahead.
Thank you, Mr. Chair. I had to ask you this, Mr. Bishop, or else I'd regret it if I couldn't get a hold of you afterwards. Are you any relation to the late Frank Bishop from Presque Isle, who was in Cerny?
I am. So I am Frank Hamilton Bishop Jr. And my father is Frank Bishop Sr. So I grew up in Presque Isle. I was born there. And I promised my father I would never be an attorney. So after a failed career trying to write screenplays in Hollywood, I came back to Maine and took my dad's advice to go to the Maine School of Law. And it's the best decision I ever made.
Thank you. I appreciate your candidness. Thank you.
So I'm still a county boy at heart.
Thank you. I grew up in Presque Isle. I knew your dad.
Thank you, Representative Thorne. Are there additional questions from committee members? If so, please raise your electronic hand. And I am not seeing any. So again, thank you, sir, for bringing your testimony before the committee today. It's greatly appreciated. And before proceeding to our next step, I noticed that we've been joined by two committee members who were not here when we gave our afternoon introductions, and I'd like to give them the opportunity to introduce themselves to the members of the public watching, starting with Senator Lisa Keim.
Good afternoon, everyone. Sorry to have jumped in and created an awkward moment for everyone. My name is Lisa Keim, and I am proud to represent Senate District 18, which is Northern Oxford County, in two communities in Androscoggin.
Thank you very much, Senator Keim. And I thought I saw Representative Hagan, but I'm not seeing him. But if you are here, Representative Hagan, please let us know and you can introduce yourself. Well, if he joins us later, we will give him that opportunity. I will just check the attendee room to see if there's anybody else that wants to be heard on this nominee. Please raise your electronic hand. I am not seeing anyone, so I will proceed to the concluding statement by the chair. All public comments having been taken, the committee will now proceed as follows. Review any additional written comments on the nomination that have been received by the committee. Vote on the nomination and notify the President of the Senate pursuant to Title III MRSA Section 157 and the joint rules. The vote must be taken within 40 days from the date of the governor's written notice, and we are operating within that time frame. The hearing of this Joint Standing Committee on Judiciary for the Honorable Susan Orem of Falmouth for appointment as an active retired judge of the District Court is now closed. In accordance with the law, the committee may not take the vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all committee members who are present agree. At this time, therefore, the chair will ask whether any member present objects to proceeding to taking the vote immediately. If so, if you could please raise your electronic hand. And I am not seeing any objection, so I will move forward. The pending question before the committee is that the Joint Standing Committee on Judiciary recommend to the Senate of the 130th Maine Legislature that the nomination of the Honorable Susan Orem of Falmouth for appointment as an active retired judge of the District Court be confirmed. In accordance with 3 MRSA Chapter 6, Section 157, and with the rules of the 130th Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of recommending confirmation. A vote of no will be against the motion to recommend confirmation. Before proceeding to the vote, I would remind committee members, if you want to vote, make sure you are visible and your microphone is on. If you are not prepared to vote, don't be in the box and shut your camera off. So with that, is the committee ready for the question? And I see that we are. I would ask the committee clerk, Supi Panet, to please call the roll.
Thank you, Mr. Chair. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier. Senator Keim.
Yes.
Senator Keim votes yes. Senator Sanborn. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby. I will recall the absentees. Representative Poirier. Representative Poirier is absent. Senator Sanborn. Senator Sanborn is absent. Representative Hagan.
Hi there. I apologize. I've had some internet difficulties. I would vote yes.
Representative Hagan votes yes. Representative Libby. Representative Libby is absent. Representative Poirier.
Yes.
Representative Poirier votes yes.
Thank you, Committee Clerk Supi Panet. If I have my math right, 12 members of the committee having voted in the affirmative and 0 in the negative. It is the vote of the Joint Standing Committee on Judiciary that the nomination of the Honorable Susan Orem of Falmouth for appointment as an active retired judge of the district court be confirmed. Congratulations, Judge Orem. We thank you for your service. Were we in more normal times, we would be coming out of the horseshoe and congratulating you individually and thanking you for your continued service. But those are not the days in which we live right now. So please accept our virtual round of applause for all the work that you've done and that you will continue to do for the people of Maine. Thank you.
Thank you all so much for your time and patience today.
Thank you. And with that, committee members, we have one more confirmation hearing scheduled for 3 o'clock. And I was advised by my erstwhile committee clerk that I cannot start that until 3 o'clock, even if I want to. So you guys have about a 10-minute break. If you could please be back on mic and on camera at 3 o'clock, it would be greatly appreciated. Thank you.
Representative Hartnett.
Yes.
I have to leave at 3:30. I expect it'll be no district. I assume that we'll get well into the testimony before then. If I have to leave, it's not because of any disrespect. It's just something I had to attend and I couldn't change it once the schedule came out. So
Perfectly understood. No need to worry at all. We'll see you at 3 o'clock and get you so that if you need to leave, you'll be free to do so.
Great. Thank you.
Thank you. And just remember to shut off your cameras and mics until we see each other at 3 o'clock. Good afternoon, Judge Jordan. How are you? Welcome back. We will give committee members a couple more minutes to join. Okay, we're now at 3 o'clock. If there are committee members that can hear me who have not activated their cameras, please do so that we can move on to our final hearing, confirmation hearing of this afternoon. And I'm seeing 1, 2. Okay, it is now 3 o'clock when we are scheduled to start. Hopefully we'll be joined by a few more committee members as we move forward. Welcome to the Judiciary Committee. We will now be hearing our final confirmation hearing of the day. This is a public hearing of the Joint Standing Committee on Judiciary for the purpose of considering the nomination by the Governor of the Honorable Bruce Jordan of Vesey for appointment as an active retired judge of the District Court. Under the law and joint rules of the legislature, this committee is required to hold this public hearing and to recommend confirmation or denial of the nominee by majority vote of the committee members present and voting. As chairs of this committee, Senator Carney and I will then send written notice of the committee's recommendation to the President of the Senate. The committee will hear testimony from and have an opportunity to question the governor or her representatives, the nominee, and other persons who wish to speak for or against the nomination. This meeting is currently being live streamed on the committee's YouTube channel. This means that anyone who is a participant, a panelist in the meeting via Zoom, can be seen and also heard whenever their microphone is unmuted. People testifying cannot be seen or heard until they are called upon to speak. This meeting will be recorded and available to view on the committee's YouTube channel shortly after today's proceedings have concluded. Pursuant to Title III, Section 157 of the Maine statutes, which requires that there be an affirmative motion to recommend confirmation of the nominee, the chair recognizes Representative Jennifer Poirier for the purpose of making such a motion. Representative Poirier.
Thank you, Mr. Chair. I move that the Joint Standing Committee on Judiciary recommend confirmation of the Honorable Bruce Jordan of Vesey for appointment as an active retired judge of the District Court.
Thank you, Representative Poirier. Do I have a second to the motion? Seconded by Senator Carney. Thank you. Members of the public should know that a copy of the statutory requirements for this position is available online and accessible to the public. I will now turn to the governor's representatives. We now recognize Jerry Reed, the counsel for Governor Janet T. Mills, for the purpose of making a statement concerning this nomination. Welcome back for the final time today, Mr. Reed, and please proceed when you're comfortable.
Thank you. Good afternoon, Representative Harnett, Senator Carney, members of the Judiciary Committee. My name is Jerry Reed. I'm counsel to Governor Mills, and it's my pleasure to be here this afternoon to present the Honorable Bruce A. Jordan as the governor's nominee for appointment as an active retired judge of the Maine District Court, from which he retired as an active judge on October 29th of last year. Judge Jordan was appointed to the District Court in 2010 and reappointed in 2017. Prior to joining the bench, Judge Jordan was a family law magistrate in the District Court, working primarily in Penobscot, Piscataquis, and Hancock counties, a position he held for about 3 years. Before that, he worked for 11 years in private practice with a focus on criminal and family law matters. Judge Jordan graduated from the University of Maine at Orono with a degree in political science and the Franklin Pierce Law Center. Judge Jordan sat primarily in Bangor, but also in Ellsworth, Lincoln, Millinocket, Newport, Holton, and Calais district courts. And he served as the regional scheduling judge from 2012 to 2020. Judge Jordan has deep knowledge of the criminal and domestic relation laws that are at the heart of the district court's work. He's an efficient and productive judge and a clear communicator who maintains orderly proceedings while being respectful of the litigants appearing before him. His continued service as an active retired judge will be of great value to the court. On behalf of the governor, I respectfully request your support for the nomination of the Honorable Bruce A. Jordan as an active retired judge of the Maine District Court, and would be pleased to answer any questions that the committee may have of me. Thank you.
Thank you very much, Mr. Reed. Are there questions from committee members for the Governor's Counsel, Jerry Reed? If so, please raise your electronic hand and I will call upon you when I see that. And I am not seeing any electronic hands in the air, so thank you very much, Mr. Reed. And I will now turn to John Hobson, who chairs the Judicial Selection Committee for the Governor. Thank you for being here again, and please begin your statement when you're prepared to go.
Thank you very much, Representative Hartnett, Senator Carney, members of the Joint Standing Committee of the Judiciary. My name is John Hobson. I am chair of Governor Mills's Judicial Selection Committee, and on behalf of the committee, I request that this committee act favorably on the nomination of former Judge Jordan to become active retired Judge Jordan. Judge Jordan sat, as Mr. Reed said, primarily up Bangor and Northeast, and was a solid contributing member. He has a history of public service. Prior to being named to the bench, he sat as a family law magistrate, and he has a knowledge of the law, family law, and criminal law, as Mr. Reed also said, that allows the docket to move quickly, efficiently, but fairly. He had a reputation for listening, but being able to move the docket. And the practitioner in that area have come to know Judge Jordan as someone who kind of gets the job done, but does it in a way that their clients feel that they've been heard and that they get a sense of the court that's a favorable one. I think there was a previous nominee that said that, it may have been Judge Oram, I can't remember, said that when someone comes into the courtroom, the judge standing there is the judge, the judicial branch to that person. It's the entire judicial branch, because that's probably the only contact they're going to have. And Judge Jordan, during his time as an active judge, and hopefully his time as an active retired judge, has been a very good representative of the judicial branch in the state of Maine to the citizens of the state of Maine. He's been a solid figure dispensing justice in a fair and even-handed way. And my request, and the request on behalf of the committee, is that this committee allow Mr. Jordan, or soon to be hopefully active retired Judge Jordan, to continue with his public service and serve the people of the state of Maine. And with that, of course, I'm happy to take any questions.
Thank you very much, Mr. Hobson. Are there questions from committee members for Mr. Hobson? If so, please raise your electronic hand. I'm going to give a minute. Well, actually about 20 seconds. And not seeing anyone. Thank you very much for your time today, Mr. Hobson. We know you have some pre-existing commitments. If you need to leave, please leave when is necessary. Thanks.
Thank you very much.
And we'll see you again tomorrow.
Yes.
I am certain. Thank you. I will now turn to the nominee. The chair now recognizes the Honorable Bruce Jordan for the purpose of making a statement concerning this nomination. Judge Jordan, welcome to the Judiciary Committee. Thank you for your prior service, and please begin your statement when you're comfortable.
Thank you very much. Senator Carney, Representative Harnett, members of the Judiciary Committee. My name is Bruce Jordan, and I'm from the town of Vesey, and I am here to discuss with you the nomination to the position of active retired judge. I do want to first thank Governor Mills for the opportunity to continue serving the people of Maine in this position. Now, as has been stated, I retired last October and from full-time work as a judge, and I feel that moving on to the active retired position enables me to bring along my 23 years of experience and then 12 years as a magistrate presiding in the family court, and then my 11 plus years as a district court judge to assist the people and continue serving them in the role as an active retired judge. As has been stated, I practiced for over 10 years in a small firm, and I was primarily doing trial work, a fair amount of court-appointed criminal and child protective work and other civil matters. And in 1998, I was chosen as one of the original eight family court magistrates, and I served there for 12 years. And I won't go through the parts how I've been nominated by a couple of different governors. I have served as the regional scheduling judge, as was indicated, I believe, by Mr. Reed, and that position is an administrative position in which you're required to work on coordinating and assigning judges and resources to making sure the court works as efficiently as possible. And I was the chair of the Family Law Advisory Commission for 2 years, a job that I enjoyed, but that I had to move on from, a role that I enjoyed. I am blessed to have been married for 37 years, and my wife is a recent retired small firm attorney also. I have 2 children. My oldest is a civil engineer working as a supervising engineer in a large construction company, and have 2 grandkids. And then my son is a physician's assistant in the Bangor area, and we're extraordinarily proud of both of them. On a couple of different occasions, one when Mr. Reed was speaking, one when Mr. Hobson was speaking, and one when Representative Harnett was speaking, my end of the screen froze up. My connection stayed the same, but I don't think I missed an overly large amount. But if you see me pausing and waiting to respond, I will let you know if it's frozen on this end again. But I apologize for that. That again is part of the Zoom world we live in. If you have any questions, I understand that it's been a long day, a lot of hearings, but if you have any questions for me, I'm more than happy to answer them.
Thank you very much, Judge Jordan. I will now turn to committee members to see if they have any questions of the judge. I will begin with Representative Reckitt, followed by Representative Babbage. Representative Reckitt, go ahead.
Thank you. That's been a long day. Judge Jordan, I noticed a couple of things. One is that you had the questionably, well, you were on the Performance Council of the Courts, which I served on once for a couple of years. It was one of what kept me going was, it was when Judge Wathen was the Chief Justice. And he and I sat together, and that part I enjoyed. But the rest of it, it was incredibly boring. Reminded me of strategic planning at every group that I ever was in that I didn't want to be in doing strategic planning. So I hope that you had a better experience than I. It wasn't bad, it was just boring. So the other piece is a bigger piece that I
Yeah,
noticed.
you've frozen again.
Oh, did I?
From my end.
Okay.
You froze, pardon me, Representative, you froze right at the spot where you were explaining, I think quite accurately, how boring and tedious a lot of the practice, the planning for that was back then.
Yes, yeah. Can you hear me now?
I can hear you, ma'am.
Okay. I wanted to talk to you about your, and it looked like a variety of different roles you played in a connection with the Penobscot Nation. I saw that you were the supervising attorney of the Public Defender's Office, and had some other interactions with the tribes. I wanted to know what brought you to that work, or was it just, I think one of them was when you were a private practitioner, which means what probably brought you to it is somebody came with a case. But I mean, my question is, have you had much experience in that arena? I assume so from where you've been working.
Yes, and you mean dealing with the tribal court, members of the tribe and cases? Yes, what brought me to that was I had represented a number of tribal members in criminal cases. And I had done that both in the state courts, and then I had done it at the tribal court. I found the tribal court very interesting. It was fascinating, all the dynamics of how that court system worked in a small community. And they came open to have a supervising attorney who supervised the paralegal, and then also did some of the own trial work. So they hired me on to do that. I was happy to do it, and I enjoyed the work, and I worked with some very good people, very interesting people, and some fascinating work. But it demonstrated quite clearly that, I don't want this to sound right, but people are people. Everybody has the right to be treated with respect and decency and civility, and to have their problems heard and the problems sorted out. But it was a very good experience for me.
Thank you. If I could just follow up, Representative Hartnett, I lost you on the screen.
I answered the question I thought you asked because it froze halfway through, and then I heard the last part of your question. So if I didn't answer it correctly, didn't answer what you were asking, please let me know.
No, you did. What I'm trying to figure out is, having had that experience working with the tribal court, do you have an opinion that that's appropriate for you to share or not share? This may not be an appropriate question. Let me start with that, because I don't want to put you in a spot where you feel you have to answer something you shouldn't. But it seems to me that if we could just solve the issues around criminal and civil cases in the nations, it would make life a lot easier for a lot of people. And it's tangled up with the whole sovereignty question and all of those things that we're dealing with in the legislature or not dealing with. Do you have opinions around those issues and how it might impact the courts in the future?
I'm going to be very careful how I address this, because as you stated, some of it deals with sovereignty, and those are political issues, and that is not the purview of the court to get involved. I know that the difficulty, we've had some discussions a number of years ago with the judge at the tribal court in the Penobscot Nation, and some of the other people there, and they wish to try to do a blending of, it's hard to describe in a few short words, but some
I believe we have lost.
We are a separate court.
Judge Jordan, you froze up there after saying that this might be a difficult question to answer as it's political in nature.
Okay. The sovereignty and jurisdictional issues of two separate courts make it extremely unwieldy and difficult to talk about having them work together. And beyond that, I really am not comfortable answering that kind of question.
All right, thank you.
Thank you, Representative Reckett. Does that conclude your questioning? Thank you. Thank you, Judge Jordan. Representative Babbage.
Thank you, Chair Harnett. Appreciate it. And hello, Judge Jordan, and congratulations on this nomination. Thank you for willing to serve in a time that we very much need you. Judge, all day long we've heard about serving during the time of COVID, but could you be specific as to how your day-to-day or week-to-week job description or daily professional life may have changed during these last 18 or 19 months of your last term?
Yeah, I think the principal word is frustration. The job you're appointed, nominated, and confirmed to is to help people sort out problems following the facts and applying the law. And to know that you have this hugely building caseload and problems out there that are not getting sorted out, that are just sitting, and you can only handle them in a kind of titrated manner. You can only have 8 people in the courtroom at this time and 10 at that time, and you do these things. And so you sense the also look at people's safety and well-being and everything else. It's been the challenges, in addition to the frustrations, that you try to figure out ways to get these things accomplished by using alternate methods. We did a lot of Zoom where possible. That has its limitations, quite frankly. We did telephone conferences as things as much as we possibly could, and we're constantly brainstorming, trying to find ways to make the cases be brought forward and to be resolved.
I got most of that, so
Okay.
yes, yeah. And so thank you for that. I envy the status of active retired judge, and I'm delighted that you're able to transition slowly. I wish there were an active retired legislator, but I guess in a citizen legislature, I guess that's called citizen. So thank you. Thank you for continuing to serve.
Thank you, Representative Babbage. And Judge Jordan, your connectivity illustrated the frustration that you were discussing. But we did get the gist of your testimony. Okay. Thank you. Are there additional questions from committee members for Judge Jordan? I am seeing none, so thank you very much. We'll now move on to hearing from members of the public. Statements from the floor. The chair will now take comments from persons attending this hearing who wish to speak for or against this nomination. Anyone who has a written statement but who does not wish to speak should have submitted the statement to the committee clerk prior to today's hearing. All such statements shall contain the name and residence of the person who prepared the statement. A copy of each written statement presented to the committee at this hearing will be made available to the nominee upon his request prior to the committee's vote, and the nominee will have an opportunity, if he chooses, to respond to the written comment. Those who wish to speak in person registered with the committee clerk prior to the start of this hearing and will be called upon by the chair, at which time they will be promoted to a panelist in Zoom, where they will be able to be seen and heard. When it is your time to speak, please observe the following. State your name and place of residence before delivering your testimony. Only comments concerning the suitability of this nominee for this particular position will be considered in order. All other comments will be considered out of order. After you are done speaking and there are no more questions from the members of the committee, you will be returned to attendee status and the next person will be called. At this point, I am going to look at the attendee room and to see if there are any persons in the attendee room who wish to provide a comment or testimony. And I would ask the committee clerk, Supi Panet, to please move over Frank Bishop to panelist status. And I will wait for Mr. Bishop to travel through cyberspace, and he has arrived. Please begin, welcome back. Please begin your testimony as soon as you're comfortable.
Senator Carney, Representative Harnett, and members of the Judiciary Committee, my name is Frank Bishop, and I'm here as president of the Maine State Bar Association to deliver testimony in favor of the nomination of Judge Bruce A. Jordan to the Maine District Court as an active retired judge. As I've mentioned for the other nominees, the MSBA sends out electronic surveys to all practicing lawyers in Maine to evaluate court judges, generally in the 6th year of a judge's term. We take those surveys, review them, and then compile the surveys into a report that's delivered to our Board of Governors. And then the Board of Governors moves forward either to support the nomination or not. And a summary of Judge Jordan's evaluation show that Maine lawyers find him to be intelligent and thoughtful, yet decisive and practical. He is described as respectful, fair, and always prepared. Judge Jordan is praised for his knowledge of substantive law, and all those that come before him appreciate his balanced approach and experience in the courtroom. Attorneys also value his ability to run a tight, efficient, and controlled courtroom. These traits have earned Judge Jordan the support and respect of MSBA members, and we think Maine citizens will benefit from his continued service on the Maine District Court as an active retired judge. So based upon the survey responses, we urge the Judiciary Committee to give its unanimous support to the nomination of Judge Bruce A. Jordan to the Maine District Court. Happy to answer any questions that any of the committee members may have.
Thank you very much for your time and testimony today. And Representative Babich, I see your hand is still up. I assume that was left over. Am I?
That is residual. I'll take it down. Thank you.
Thank you very much. Are there questions from committee members for Frank Bishop? If so, if you could please raise your electronic hand and I will recognize you once I see that. And I am not seeing any. I'm just going to check the chat. No. Again, thank you very much for all of your time today.
And before I go, Representative Harnett, I wanted to offer up to the committee, I know your time over the next several months is jam-packed with hearings and work sessions. But if you would like to, by Zoom, meet with the Board of Governors of the Maine State Bar Association, I'd be happy to facilitate that. We did do that a couple of years ago, and I thought it was worthwhile. Also, if there's anything we can ever do, if there's work that you would like us to do to support in any way what you guys are doing, given the difficulties in the court system right now, we're here to be a help. So thank you very much for your time today.
Well, thank you very much for that. And those issues are something that are of great concern to this committee. So we very likely will take you up on that offer and greatly appreciate it. Thank you. Seeing no other, actually any persons in the attendee room, I will now make a concluding statement. All public comments having been taken, the committee will now proceed as follows. We will review any additional written comments on the nomination that have been received by the committee that we have not seen. Are there any such submissions, Supi?
There are none, Mr. Chair.
Thank you. I probably should have asked that the last couple of hearings. We will vote on the nomination and notify the President of the Senate pursuant to Title III MRSA Section 157 and the joint rules. The vote must be taken within 40 days from the date of the governor's written notice, and we are well within that time frame. The hearing by the Joint Standing Committee on Judiciary for the Honorable Bruce Jordan of Vesey for appointment as an active retired judge of the District Court is now closed. In accordance with the law, the committee may not take the vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all committee members who are present agree. At this time, therefore, I will ask whether any member present objects to proceeding to taking the vote immediately. If so, please raise your electronic hand. And seeing none, we will proceed to the vote. The pending question before the committee is that the Joint Standing Committee on Judiciary recommend to the Senate of the 130th Maine Legislature that the nomination of the Honorable Bruce Jordan of Vesey for appointment as an active retired judge of the District Court be confirmed. In accordance with 3 MRSA Chapter 6, Section 157, and with the joint rules of the 130th Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of recommending confirmation. A vote of no will be against the motion to recommend confirmation. Is the committee ready for the question? Seeing no objection, I would ask the committee clerk, Supi Panet, to please call the roll.
Thank you, Mr. Chair. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Senator Sanborn. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan.
Judge Jordan, as a proud alum of the Vesey Vikings, I vote yes.
Representative Hagan votes yes. Representative Libby. I will recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Libby. Representative Libby is absent.
Thank you very much, Committee Clerk Panet. 12 members of the committee, having voted in the affirmative and 0 in the negative, it is the vote of the Joint Standing Committee on Judiciary that the nomination of the Honorable Bruce Jordan of Vesey for appointment as an active retired judge of the District Court be confirmed. Judge Gordon, congratulations. Thank you for your past service, for your continued service moving forward. Typically, although it's not typical anymore, but we used to in the olden days, come down from the horseshoe to recognize and congratulate you and offer our best wishes for your future work on behalf of the state, the people of the state of Maine. But we can't do that today. What we can do is our next best, and that is to offer you a virtual round of applause for your stellar career in public service. Thank you and congratulations. And now it froze on my end, but now the hands are clapping. So hopefully everybody can hear me. That concludes the work of the committee today. I will close the hearing on the confirmation of Judge Jordan as active retired. Thank everybody who participated in today's confirmation hearings. Thank the members of the Judiciary Committee and also our analyst and our committee clerk, Panette. And I do want to give the opportunity, Judge Jordan, if you would like to say anything. I'm sorry.
Yes, thank you, I would. And I would like to thank you all for your time. And thank you very much for your vote of confidence. I will do all I can to make sure it is deserved and you don't regret it.
Again, thank you very much. Congratulations. And committee members, we will pick up tomorrow morning with 4 more confirmations beginning at 10 o'clock. Thank you. Enjoy the rest of your day. And thanks for all your effort. Take care.
Right. Good night.
There, are we back? Oh, I guess we're done. Thank you. Could you folks hear me when I? Oh, yeah, I can't. She's on mute.
Let me unmute myself. Is there anything I can say to mention to the chairs?
I don't know if you heard what I said, because when I was finished talking, it was frozen and I didn't know if they heard everything I said, but.
I believe I know I did, so I
Okay.
believe everybody did. And was that your wife that did the cameo? Oh, he's frozen. Oh, Heather. Heather, can you hear me?
Now you're back, you're unfrozen again, but yes, now I can hear you. And that was all I had to say. I very much appreciated everybody's time, but.
Judge Jordan, actually, there's a new member of our committee. Unfortunately, she's joined too late to vote for you, but this is Senator Heather Sanborn.
Good afternoon.
Senator Sanborn, our last nominee, Judge Jordan.
Yes.
All right. Has the vote already been taken?
Yes, all have, and unfortunately I can't. You have to be on camera during the hearing.
No, I know. We just wrapped up our confirmation hearings over my other committee, so I thought I'd swing over and see if you were still hard at work here in judiciary. So,
well, hopefully you can join us tomorrow for 4.
I will be there for some of them. I have to miss. I have a meeting in the morning, but I'll be there for as much as I can be. So nice to see you, Subi. Take care. Nice to see you. Bye-bye.
Thank you. You also. Thank you. Bye-bye.
Congratulations.
Thank you again.